Hello, how are you?
Just go in our notebook.
I don't know why they left that here. I hope that.
I'm ready.
I got one right there.
Maybe there were others too. I know I have a notebook.
It's 2 p.m., July 12th, 2018,
You may be right.
and I call the Code Enforcement Board meeting to order. Madam Clerk, would you please call the roll?
Chair Archer,
Here.
Vice Chair Weeks, not here. Ms. Dabbs?
Here.
Ms. Wade?
Yes.
Mr. Kramer?
Here.
Mr. Robinson?
Here.
Ms. Norfleet?
Here.
To ask Attorney Trask, would you please give the invocation and lead us in the Pledge of Allegiance? Would everyone please stand?
Heavenly Father, we seek blessings on the tasks before us. Bless our efforts with clear insight, our deliberations with wisdom, our work with clarity and accuracy, and our decisions with impartiality. We pray that our work this afternoon will find favor in your sight. This we pray. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. I will now read the Code Enforcement Board hearing procedures. It is the intention of this board to promote, protect, and improve the health, safety, and welfare of the citizens of Tarpon Springs by providing an equitable, effective, and inexpensive method of enforcing various codes within the city of Tarpon Springs. Any aggrieved party may appeal a final administrative order of this board to the circuit court. Such an appeal shall be filed within 30 days of the execution of the order to be appealed. Florida Statute 286.0105 requires any party appealing a decision of this board to have a record of the proceedings to support such an appeal. The procedure of this board is as follows. First, the city presents its witnesses and exhibits, after which the alleged violator is able to ask the city's witnesses any specific questions regarding their testimony. Secondly, the alleged violator is allowed to make a presentation and present his or her witnesses and exhibits. Then the city can question the alleged violator's witnesses. After both rounds of testimony, both on the part of the city and the part of the alleged violator, each party is asked to give a closing argument, first by the city and then by the alleged violator. After those three steps are taken, this board will close the public hearing portion of the case to discuss it and take appropriate action. Before we begin the public hearings, we will have all potential witnesses stand up and be sworn in by the secretary of the board. So anyone that's going to speak, please stand and raise your hand.
Raise your hand. Do you swear from the testimony you're about to give in these proceedings is the truth, the whole truth, and nothing but the truth? I do. Thank you.
And we ask that you please turn off all cell phones. We're going to one. Okay, we're ready for new business. Case number 18-800000146, 482 Riverside Drive, Sally Diener, Victor Randolph. Is there anyone here from?
Yes, Your Honor. Oh, yes.
Okay. Could you please give your name and your relationship to the property?
I'm Mike Kuskudis. I actually represent the parties here.
I can't hear you.
Mike Kuskudis. Can you hear me? Okay. Mike Kuskudis in Michael Kuskudis, PA. I represent both Sally Denier and Victor Randolph.
Madam Chairman, the first case as well as the second case are the same people as the same address, and they tie together. Do you want us to do them separately or together?
Separately.
Separately, please.
Yes, ma'am.
Oh, sorry, this is the first time for me, guys.
Okay.
So, case number 18-800000146, address 482 Riverside Drive, and what's the name? Sally Dean and Victor Randolph.
Sir, if you could tell us who you are and what your job responsibilities are here at the city.
My name's Derek Silver, and I work for the city of Tarpon Springs. I'm a site inspector.
Ask about the,
Yeah,
pedestrian.
hang on just a second. Yeah.
Kuskudis, do you have any objection to documents and photographs being put in as evidence?
No, I do not.
Please receive those, Michelle. Okay, go ahead, sir.
All this. All of the photographs and exhibits that were given to the violator are accepted copies of what is being presented to the board. All notices were mailed to the property owner of record and demeaned by Pinellas County property appraisers and tax collectors. All NOVs and NOHs are sent certified return receipt and first-class mail. Please accept all exhibits into the record as advised.
Just for clarification, the admission of these documents into evidence is by no way an admission of any violation. I think the pictures speak for themselves, but there are narrative parts of this notice of violation that may be subject to question or dispute.
Oh, in my inspections, I saw that they were putting fill in without a permit on date 3/5 of 18. I mailed a notice of mailed a certified and first class notification on 3/13 of 18. Return inspection on 3/30 of 18, no changes. And then on 3/30, a final NOV was mailed. On 4/18, a re-inspect was done, and pre-permit was complete and taken care of. 14 to 21 days approval. Let's see. And then on 5/23 of 18, I did another re-inspect on tilled land removed.
I just caution about coaching the witness.
Yeah, this should be only your testimony. You should not be asking others. You know, if you have a question about how you are moving forward with your testimony, you can direct them to the chair, but you should not be directing them to anybody else over there, just so you know. Okay.
Any other?
You can continue on.
Okay. Basically, in my eyes, they didn't pull a permit for bringing in dirt, and that's why they were violated.
What is the code section that they're being cited for?
No permit.
Particular code
Is
section
it
you want to refer
64, I
to?
believe, for the board? I believe
Hang on,
it's
Mike.
section
Hang on,
64.
Mike. I just let them testify.
the code violation number is 64.00, and it's A.
You through? Does the board have any questions for, I don't, got his name.
Derek Silver.
I did, I was looking for dates on the phone.
Dates on the photos. They were at the time I did my first inspection, which was on 3/5 of 18.
And that's for exhibit 1. Photo 1.
I'm sorry, I can't hear you.
I'm just having trouble matching up the dates and the offenses.
Dates are on the pictures are on a 3/5 of 18, along with the stop work order. And then the re-inspect is on 3/30. Would be the second set of pictures.
Mr. Koskoutis, do you have any questions
Yes, I do.
for the city?
As a site inspector, obviously you're the one who has precipitated this being a code violation. Would that be a fair statement?
Yes.
Okay, and your violation basically indicated that they had put fill on the property. Is that a correct statement?
Correct.
Okay, and you cited them for bringing fill onto the property without a permit.
Correct.
Okay. In the code, you're as a code enforcement, or whether you're an officer or in charge of enforcing our codes, do you know what constitutes fill? For example, if I have flower beds at my house and I bring in a truckload of dirt to fill in my flower beds, would that constitute fill?
Yes.
Okay, so would I need a permit if I wanted to put dirt in my flower beds?
Yes. It's under 6.4.
Okay,
Code.
so anybody in this community in Tarpon Springs who wants to add some dirt to their gardens, they have to get a permit from the city. That's your testimony?
Get approval from the city, yes.
Okay. What constitutes fill? Under the section 64, what constitutes fill?
C.
How does a code define fill?
Any build. I don't have it right in front of me.
Okay.
The actual one.
Okay. I would venture to guess if I gave you the code and I asked you for a definition of fill, I would present to this board that there is no definition of fill. How do you define excavation? How does the code define excavation? I see the words, but I know the code has a list of definitions, does it not?
I don't have it in front of me.
Okay,
so,
but the code does have a list of definitions.
I'm sure it has
Okay.
something.
And do you know if there's a definition for excavation within the code?
I don't, like I said, I don't have it in front of me, so.
Okay. So I guess my concern is at what level do you determine whether or not it constitutes fill? If I call my neighbor, if I see my neighbor working in their yard and adding dirt, are they in violation of the code?
Well, they were bringing in fill.
But how much dirt? Is there an
no
amount?
Determination.
Pardon?
There isn't. I don't think there's a determination amount.
Okay, so if I have a bucket, a sand pail of dirt, would that be a violation?
I'm not sure. It all depends on how the code is written.
Okay. Well, you're in charge of enforcing the code.
Right.
Okay. So you've got to make a determination whether or not that constitutes a level that would bring rise to a violation, does it not?
I would think, but
Okay.
I don't know per code. I don't have it in front of me.
Okay.
So.
Okay. Well, if you're asking my clients or telling this board that they're in violation of the code, you actually should be aware of specifically the code itself as to what constitutes a violation. Would that be a fair statement?
I'm assuming, yes.
Okay. Do you know, and did you get a chance to talk to the contractor, the landscaping contractor who did this?
On the
Mr.
site, yes.
Lucas? Did he let you know that he actually removed some of the fill?
I think I remember him saying something about
Okay.
that, yes.
So he removed some dirt. Do you know how much he removed?
No, I wasn't standing there.
Okay. Do you know how much he put back?
No,
Okay. So you don't know if he put back as much as he took out. Correct?
correct. I wasn't standing where we did it, but
I'd like, just for the sake of clarity, I'm looking at the pictures that you've provided. Okay, and it does show some movement of dirt. Those are the ones you submitted in evidence, correct?
Mhm.
Okay. I'd ask this board,
Mike, cross-examination.
well, they're in evidence, and so I want to make,
You'll have the opportunity to argue your case. This is time for cross-examination.
well, I am, but
Okay.
you've submitted this evidence, so as part of my examination, I wanted to take notice of the exhibit,
Okay.
which I think is permitted.
So, Michelle, do you have the exhibits down there? And Beth or Steve, can you grab those and hand them back so that, I want them to look at the evidence that's been received. Yeah.
Yeah, if I'm
Okay.
going off your stuff, the same stuff. You submitted in evidence.
So, Beth, just hand it to him. Thanks.
Are
He's-
you
he-
through with questions?
No, he's got
Yeah,
some questions about the
Yes, more,
photographs.
okay.
Yeah.
Hold on. Do you have any pictures that represent what the property looked like prior to the landscape being put in?
no, I
Okay.
don't personally know.
And I see you have pictures of after the fact. Is that correct?
Yes.
Okay. So your biggest concern or the purpose of this violation is that we brought some dirt in?
Correct.
But you don't know how much?
No,
You don't know how much was taken out?
No.
You don't know if enough was taken out and the same amount put in?
I would, like I said,
Okay.
I wasn't there, but from my eyewitness, the dirt level was higher, so
Okay.
obviously, yes.
But you don't know if it was compacted before he took it out. So if you have a volume that's compacted versus a volume that's loose, the volume that's loose would look bigger, would it not?
Yeah, I'm sure
Okay.
there's a fluff factor, yes.
I don't have any other questions at this point.
Okay, you can go ahead and present your case now.
Okay. Well, I don't, and maybe Mr. Trask could give me, I would ask, Mr. Trask,
Mike.
if I could request like a directed verdict or a directed before I present evidence, because if this board feels that there's no violation, then there's no reason for me to present evidence.
Okay, so yes, the answer is yes, Mike. So what is being asked of you is based upon the testimony and evidence that you've received right now, Mr. Kuskudis is asking the board to find that there has been no showing of a violation, and based upon that, you should rule without him ever having to put on any type of evidence. So, Madam Chair, you are the person that makes that determination. It's not done by motion. It is done by your finding, so that you make that decision as to whether or not the city has put on sufficient enough evidence to move the case forward. So the appropriate answer would be either you're granting it and you're dismissing the case, or you're denying the motion.
Can we ask him any more questions?
Do you have more
Board have
questions?
Any more questions for Mr. Kuskudis?
Oh, he can't answer questions for you.
Can't?
No,
Okay,
no.
for the city?
Yeah. If you have questions of the city, this is a quasi-judicial hearing, you can ask questions.
No questions?
Could we read the ordinance, please?
Yes, it's in the packet that went down that
Good
direction.
look, I did not
Yeah.
find it.
Here, I'll give you a copy of mine.
If you want, I can I have, where'd that evidence go? It went back? Okay. So, Michelle, why don't you give me the rest of the packet? I'll read it. Okay, I'm going to go ahead and read the section that has been referred to so far. So this is section 64.00. It's titled Excavation and Fill. Subparagraph A was highlighted, and it reads, "The fill, excavation, or alteration of the natural grade of land shall require a permit issued through the building department after review and approval by the city engineer." The other highlighted paragraph is paragraph C. "No permit for the fill, excavation, or alteration of land shall be issued unless those applicable to the circumstance of the following have been obtained. Number 1, site plan approval. Number 2, building permit approval. Number 3, approval of a drainage plan by the city engineer. And number 4, permits from other affected agencies or jurisdictions." I've only read the highlighted portions that had been tendered into evidence, but there is obviously, it's a little bit longer than that in the code. Mike, is there anything else you wanted me to read?
No, because
Okay. All right, so that's,
B is not applicable to this.
so the other paragraphs, I guess I'll just go ahead and read them. So B reads, "Excavation as a primary use of the site for the sole purpose of selling excavated material shall require conditional use approval from the Board of Commissioners and shall conform to the following requirements." And it lists 8 subparagraphs. I'm not going to read that since that does not apply. Paragraph D, "In the review and granting of administrative approval for an excavation permit, the city engineer may request compliance with any of the items under paragraph B above." And subparagraph E, the only one left, "The encroachment upon any associated wetland shall require compliance with the wetlands protection provisions of this code." So I think I've read the pertinent portions of the code. So, Madam Chair, then, you've heard the code section, and we have Mr. Kuskudis's motion at this point for a directed verdict, which basically is he's arguing that the city has not put on sufficient enough evidence for a case that he would have to refute by way of putting on additional testimony and evidence. So you have to make that determination whether you're going to grant the motion or deny it.
He's not building a house? What exactly is this for? To take dirt out and what
What did they do?
what was the purpose of this in the first place?
They made an island
I'm sorry?
for planning.
So it's part of a home?
It's a driveway. To me, it's a driveway.
But it belongs to someone's home?
Correct. It's a shared driveway.
And to do this, are they supposed to get a permit?
Yes.
How many different permits? Just one, or?
Just the one fill permit.
And they
They don't
started,
need one for landscaping, but they still need a fill permit to do it.
okay, and they started this without pulling any permits at all?
Correct.
Then I think we need to go on with it.
Okay, so the motion then, Mike, is denied. Do you want to put on your witnesses?
At this point, I'd like to call Mr. Lucas.
Mr. Lucas, were you sworn in a little while ago? Okay.
Mr. Lucas, please go ahead and state your name for the board and your occupation.
Hey, my name is Craig Lucas from Lucas Landscaping.
Okay. And how long have you been in landscaping business?
I've been about 10 years.
Okay. And in your role as a landscaper, Are you familiar with the necessity of having to pull permits when necessary?
Yes, I am.
Okay. Before being a landscaper, were you a site contractor?
Yes, I was.
And as a site contractor, you were familiar with having to pull permits anytime there was site work?
Correct.
Okay. You did not initially pull a permit for this, is that correct?
I did not,
Okay. Is there a reason why you did not believe a permit was necessary?
because the amount of fill and dirt that was removed, it is just ridiculous.
What does that mean?
Well, if you people could see what the situation is and what we have done, I don't think there'd be any issue here. I mean, we removed perhaps 6 to 7 yards and added to that perhaps 4 to 5 yards on top of that. That's all we did. We didn't change any elevation to speak of. I have pictures here of where the original elevation was, because there's a wall there and it was painted, and you can see where they painted, and we stayed below that,
Do
actually.
you have a picture of that?
Yes, I do.
Is this an accurate reflection of the
Yes, it is.
line?
Yes, it is.
Okay. At this point, I'd like to go ahead and show the photo report. Just that one for now. Unless there's any objection, I'd like to move this into evidence.
Yeah, hard to tell.
So is there any objection?
As
For-
far as the picture,
Yes.
it's hard to tell if it's that property or not.
Okay.
I think the testimony was that it was.
So that would be your objection, that you don't know if it's the same property?
Can't tell if it's the same property or not.
Okay.
It's just a block wall.
Okay, so. Hang on just a second.
I could
So,
proffer
Madam
who took
Chair,
the,
I would suggest that you allow it to be received into evidence for whatever probative value that it has. You've heard testimony that it is the property.
Okay.
So,
Yes.
so,
Allow it.
I could just proffer who took the picture. Mr. Lucas, did you take the picture?
Yes, I did.
And that picture is of the property?
It certainly is.
Okay. Mr. Lucas, I also want to show you a picture of the finished product. Is that an accurate reflection of the finished product?
Yes, it is.
Okay. At this point, and before you landscape, that was just barren dirt, correct?
It was.
Was it compacted dirt?
It was.
Um,
hang on a second, Mike. So you're tendering that into evidence?
Yes.
Okay. So do you have any objection to it coming into evidence?
No.
Okay. So you need to receive it
Yeah.
then?
Please receive these into evidence, Michelle.
So if you heard the testimony earlier that even a bucket of dirt would require a city permit, I mean, as a site contractor or as a landscape contractor, how many yards do you actually landscape that you'd have to go get permits for?
Everyone.
Now, do you get a chance to look at the code when you pull a permit?
I'm sorry?
When you go to pull a permit, do you get an opportunity to look at the code to make sure you're in compliance?
No, I don't.
Has anybody ever told you in all the jobs that you've done that there's a magic number of fill or what fill constitutes in order for you to put a permit?
No, this is the first time I come across it.
Have other representatives from the city been out and looked at your work where you had to pull a permit?
Yes, they have.
And was the permit required fill that they came out to see, or was it for permitting something else?
It was permitting for walls and stuff, retaining walls.
Okay. And as a retaining wall, you have to backfill or put dirt in?
Correct.
Okay. Did you have to get a fill permit for that as well?
No, I didn't.
There was a question as part of this case with regard to ignoring a stop order. You were noticed or were advised to stop work, correct?
I was.
And did you stop work?
Yes, we did.
Okay. Did you plant material though?
What happened was, Derek called me and said, I'm gonna have to shut you down. I said, well, then let's talk about it. So I called my foreman and I told him, don't do any more work, stop. He says, well, I'm talking to him right now, and as of right now, he said we could go ahead and plant,
But not put more fill.
but not put more fill. And we had all the fill added that we needed.
And the fill that you added, that you say you added, is still below the line that you took a picture of, correct?
Correct.
So the line was, what did that mean? What was that line an indication to you of being prior?
That was the existing grade.
Okay, and through erosion and everything, some of that grade had basically been displaced?
Yes, it had.
So at no time, when you were told to stop work, that the stop order was ignored, is that correct?
No, it wasn't.
Just a minute. Was let's go. Was a permit subsequently applied for?
After the fact, it was.
And it was not granted
It was not granted.
because
I really don't know why.
but you don't think a permit was even necessary.
No, I don't. Like I said, I'd have to get one for every job. I mean, this was
Landscape job?
a landscape job. I mean, I see more dirt hauled in different places every day than we hauled in. And I know they have no permit.
This concludes my, unless you want to ask my witness any questions.
Okay, does the board have any questions?
I looked at the photograph. First of all, I didn't see any island. So on the left-hand side, there's sort of a brick, and then there's a jog. Is that the island? I didn't see any island. I saw a big.
That
hole
is
in the
correct.
driveway.
Hold
That
on a
is correct.
second, Mike, you can't testify.
It's not an island. It's up against a wall. I mean, an island is, you've been able to go all the way around it.
True.
This was up against the existing wall that was there.
So the left-hand side showed sort of bricks, and then there was a jog. Is the jog where you put the dirt in?
I'm sorry, say that again?
Can you look at the photograph so you can see what I'm asking? On the left-hand side, there's some brick. Then there's a little jog and then some more brick. That is the
little
extension of the
jog?
brick what we're talking about?
Oh, that is a manhole, a cleano, I believe.
Okay, that's in the driveway. What about where the brick is? What dirt are we talking about? I can't see it in the picture. You brought a picture, and I'm trying to understand the picture.
I don't know.
I can't testify, but I can explain.
Okay, so I'm judging by not being able to understand the picture.
Any other questions?
Any other questions?
Sitting cross.
Are you asking, did we add this stonework?
No, I'm asking where is the area that you're referring to in that picture?
It is, when you drive in the driveway, it's on the right-hand side.
Okay, so in the picture, it's on the left-hand side?
If from the street, it's on the right-hand side. If you're driving into the property.
Can I proffer the picture so they're talking on the
I'd
same plane?
appreciate it.
It's already been received into evidence.
Oh, okay, it's not this little area down here. That whole area, okay, thank you.
Sorry.
So it's that planting area on the left of that photo beyond those stones, correct?
Yeah.
You kept saying right, and on the picture it's on the
Well,
left.
I'm driving into the driveway.
We're not going in the driveway.
Yeah, I see what you're saying now.
Anybody else have any questions?
Sure. Excuse me. How many loads, if any, of dirt did you bring into the site?
I brought in one load and took out a half a load.
And that one load was a cubic foot, or what was it?
I brought in about 12 to 13 yards, and I took out probably 6 to 7.
Can I ask a question of the city?
Well, right now it's cross-examination, so let's
I don't know if
finish.
anybody else has any questions for the gentleman, Mr. Lucas?
Any questions of Mr. Lucas? Okay. Mike, do you have any other witnesses? Okay. So do you have another question
I-
for the city?
I do. Why wasn't the permit granted?
The permit was granted, it was brought up to the, it was issued, submitted and everything, and then it was brought up to the city attorney because it's a shared driveway. And in the shared agreement there you have a copy of it in the exhibit, but it's a shared driveway, and that's why it needs both parties, residents, to approve it.
And the other party didn't approve it?
Correct.
That opens up a door that I could inquire further into.
Did you have your questions answered?
Yes.
Okay. So what Mr. Kuskudis is saying is that there's been additional testimony he would like to ask questions about now. So he has that right to do that, yeah.
Okay. When you say shared driveway, have you had a chance to look at any documentation with regard to the shared driveway?
Just the survey that was handed to me,
Okay.
so.
And in there, the survey, is it an easement or is it a shared driveway?
I have no idea because I didn't handle it. The city attorney handled it.
Okay. When you say city attorney handled it, what did he handle?
He reviewed it.
And,
He reviewed the documentation and the legal description of it.
okay. So our position is that you didn't need a permit. Your position is that we do need a permit, and that to the extent that the permit was denied, just so I'm clear, was because the neighbor did not sign off.
You need a permit for the fill.
Okay, well, we disagree as whether you need a permit or not. The question is your
And it was
testimony.
denied because both parties need to have signatures on it.
Okay. All right, and you looked at no documentation with regard to the constitution of the shared driveway, who's responsible for maintenance, who's responsible for what, whose ownership is that driveway? Is it an easement and not an ownership of
Mike,
the
you
driveway?
got 5 questions so far,
Okay.
so
Uh,
one at a time.
Okay. Okay. Do you know if it's an easement?
It's not my job.
Okay. But you made a decision based on what they considered a shared driveway.
I was given the decision on what.
Okay. So you didn't make the
Did
decision.
not make the decision. It's not my job to make that decision.
Okay. So you don't know if it was an easement that was, or just a shared driveway agreement?
Not mine.
Okay. All right. With that, I'd ask to call a witness, another witness.
Okay, he has the right to do that.
All right.
Which one do you want to test? Go ahead and state your name.
My name is Sally Diener.
And we're here regarding the property that you own, correct?
That is correct.
Okay, I need to find out, were you sworn in earlier? Did you raise your right hand, were you sworn under oath? Okay, thank you.
And you may have to speak a little louder. You heard testimony that this is a shared driveway. Is this a shared driveway?
The definition of a shared driveway is very vague.
Okay. Is there an easement that was granted?
There is an ingress egress easement that was granted.
And it's ingress and egress to the parties just north of you, correct?
Correct. They are the only ones that have access to cross over our property to access.
So this is a private
This is
easement,
correct.
private access, not a public access.
Correct. It is not a right of way.
Okay. When you looked at the easement, does the easement give easement rights over where the landscape was?
The easement is very specific in stating who is responsible for what. Our northern neighbors and ourselves are responsible for the paved portion of the driveway. That is the only financial responsibility they have in the entire easement area.
And who's
Us, 482 Riverside, is responsible for everything else that's not paved, financially, liability.
the ownership of that property is actually your property,
The
correct?
title is in our name. They do
Okay.
not share title.
Okay, but all they have is ingress and egress.
That is correct.
Okay, and that island that we're talking about, not the island, but that landscape piece that we're talking about has nothing to do with the ingress and egress, correct?
It was existing piece of dirt when we purchased the property.
Okay.
Had a tree. All we did was remove the tree and put fresh vegetation in so that more dirt wasn't blowing into our driveway.
Okay, so you did not expand.
Did
The-
not
the-
encroach on their
No, but
access.
you did not expand beyond the what was already there as far as that
That is correct.
planted area. Okay. You have any questions of my witness? I'm asking if the city has any
Board, do you have
questions.
any questions?
The people that
Um,
cross it, are they complaining?
I don't know who's complaining other than Mr.
Do you have any questions?
I just want to make sure, do you guys have this?
Yes, they have
in your
that.
Files? Okay. Because all that legal stuff is on that document.
There's also the easement agreement that is paragraph, other than just a picture.
No, that's the agreement.
Okay, we've shown the
Okay.
picture means-
Any other witnesses, Mike?
No other witnesses.
Okay, no cross-examination. The board doesn't have any other witnesses, so now it would be time for the city to do a closing argument.
Do you have anything else to summarize?
I don't know.
Do you have anything else, Mike?
Yes, I do. Thank you, Madam Chair. I guess my concern is this is a slippery slope, okay? The code, if you look at the section of the code, and it says fill, excavation, yet there's no definition of what fill or excavation is. The burden is on the city, not on my client to determine whether or not there's a violation. It's the city's job to show that there's a violation. And as a trier of fact, and an arbiter of this particular case, you have the ability to say, you know what, there's not enough information here. The code doesn't speak to what the violation is. Phil, anybody here who's working in their yard decides, based on the testimony of the city, adding a bucket of dirt, you'd have to run to the city, get a permit. If you put a shovel in the ground, you have to come to the city to get a permit. I don't think that's what the code's intended for. You saw the pictures. Their intent was to an existing space, to landscape an existing space as an entrance to their property. It's not putting up a building. It's not excavating a mountain. It's adding plant material with dirt that is conducive to supporting plant material. No more, no less. They took out the bad. They brought in the good. Okay? And again, this is a slippery slope. To find a violation for somebody who just brought some dirt in, I think you could ask the commission or the city to go back and revisit what the intent of this particular ordinance is. I don't think it's this. Literally, as the city testified, and you have to take their testimony, a bucket of dirt is a violation. I rest.
Okay, this portion of the case is now closed, and we will entertain a motion.
I move based on testimony, evidence, and facts presented in law that at the time of the alleged violation, sections 64.00 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. The respondent was not in violation thereof.
Any discussion? Roll call, please.
Ms. Norfleet,
The motion is to find no violation.
Okay, I didn't hear a second, I'm sorry.
There was a
Ms.
second.
Dabbs?
Missed it. Okay, not in violation. Yes.
Mr. Robertson?
Yes.
Mr.
No.
Kramer?
Wait, just
No,
call
Mr.
your name.
Kramer? Was that a
Mr.
no?
Kramer said no.
Okay, thank
Yeah.
you. Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Vice Chair Weeks?
No.
Chair Archer?
Yes.
Motion carried.
Okay, so you don't need to move on to your second motion on that, but we do need to move on to the second portion of this case.
Understood.
Ready? Number 2. Case number 18-8000149 to be established at 482 Riverside Drive, Sally Diener and Victor Randolph. We losing light in here?
My name is Shannon Brewer. I'm currently employed at the City of Tarpon Springs as an arborist. My license number is FL9221-A. I'm also an FNGLA certified horticultural professional, license number H978402. All the photographs and exhibits are given to the violator, exact copies of what's being presented to the board. All notices were mailed to the property owner of record as determined by Pinellas County Property Appraiser and the tax collector databases. All NOVs and NOHs were sent certified return receipt and first-class mail. Please accept all of my evidence into the record. This is to establish, oh, you need to wait?
Yeah. Do you have any objection to the?
No, I do not.
Okay, would you please, Michelle, accept those evidence? Thank you. Go ahead, Shannon.
Go ahead. This is to establish the case in the record. My case came from the building department, tied together with the site work. A tree was removed without a permit during the site work. And because of the root ball and all of the debris being removed, I could not get an accurate size, but a tree was removed. I went to the Google and I saw that in 2016, there was a camphor tree of substantial size located in that triangle piece of property that they were re-landscaping. Then I had sent them the notice of violation on the March 9th. Then I re-inspected on April 4th. The after-the-fact permit was not obtained for the tree removal without a permit. We mailed out the NOH on April 5th. I re-inspected on the 16th of April because that's when the permit was then obtained. And the deferrals, and you see for the CBE notice. And because they are currently in compliance, we are here to establish the case.
Board questions?
Board, have any questions for Shannon? Need to look first. Any questions? No? You have any questions?
Yeah, I do, just a few. That was a camphor tree, was it not?
Yes,
Okay.
from the photo it looked like, but I cannot determine exactly what it was because I did not see it and the permit was not applied.
Prior, I don't know, was camphor trees added to the code with required a permit? Because didn't they not require a permit previously to be removed?
That as of section 134.03, section A, they are on a protected approved tree list status.
Okay, when was that added, do you know?
I do not know. It was prior to me being hired as an arborist.
Okay. Subsequently, they've come into compliance.
Yes, they have,
Okay.
as of the 16th of April.
Okay. I have no other question.
Okay, you can go ahead and present your case then.
All right. Again, please state your name.
My name is Craig Lucas, Lucas Landscaping.
And you removed the tree.
I did.
You know, your testimony, not to restate your background. You've been doing this a while,
Yes, I have.
and you know whether or not you should have pulled a permit.
Yes, I should have.
Okay. Have you removed the camper tree before?
Yes, I have.
Was there a permit required previously?
No,
Okay. Do you know when it was added?
I do not know when it was added.
But had you known that a camper tree was added to the list of protected species, you would have pulled a permit in advance.
Absolutely.
Because you don't go around doing landscape work without necessary permit for pulling or cutting trees.
I do not.
The board have any questions?
City has one.
Mr. Lucas, are you aware that anything over 4 inches in diameter breast height requires a permit within the city of Tarpon Springs?
Any species?
There is a list of, but a camphor.
Derek and I talked about this, and I told him, I said, well, you better check your bylaws or whatever. And he came back to me and says, you're right, this was added, and we just didn't know it. I mean,
Mr. Lucas, do you know if Derek's an arborist?
I don't know if he is or not, but he's an inspector.
He's not an arborist.
Any other questions?
No, I'm done.
Okay, would you like to summarize?
They are in compliance, yes, but they did remove a substantial large camphor tree without a permit. Under city ordinance, it is required that anything over 4 inches, and you can see in my Google photo, that is a substantial sized tree. Obviously, a normal, reasonable individual would conclude that that is over 4 inches. They required a permit. They did not obtain it. They are in violation.
Do you have anything to summarize?
Yes. Well, we can't deny that we removed the tree. And ignorance is not an excuse. But, you know, as the code changes, I would, you know, again, I'm not trying to throw Mr. Lucas under the bus, but, you know, my clients rely on the contractor to make sure that the ordinances are complied with, and they did in fact comply once it was brought to their attention. And so I guess we're at the mercy of the board.
The public portion of this case is now closed, and the board will entertain a motion.
I move based on the testimony, evidence, facts presented in the law that at the time of the alleged violation, section 133.04 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. At the time of the notice of violation, the respondents were in violation of said code sections. However, they are now in compliance.
Second.
Any discussion? Roll call, please.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Vice Chair Weeks?
Yes.
Chair Archer?
Yes.
Do you want me to summarize?
Yeah.
So, Mike, I know you probably already know this, but your clients are here, so I'm just going to say it out loud. Your clients have been found in violation of section 133.04. Should they be found in violation of this code section again within a 5-year period of time, they would be considered repeat violators, and they would be fined from the date that the tree was removed. So they just need to be on the proactive approach next time they need to take a tree down.
Thank you.
Thanks, Mike.
Okay, we are going to go to number 14. Change around.
I just make one announcement that you are deviating from the printed agenda to accommodate those that are present for their cases, as opposed to going with the agenda items
Yeah.
in order. Thank you.
Good, thank you. The repeat violator in violation from 6/8/2018 to 6/22/2018 for 14 days. It's 18-800000391 at 1701 Mandalay Drive. Irene E. Miller. Estate.
Yes, estate.
Miller, would you please state your name and your relationship to the property?
My name is Robin Miller, and I'm the granddaughter to Irene Miller. This is her property, and I'm the executive, so I look after it for her.
Were you sworn
for
under
the
oath earlier today?
I was sworn in when I came in. Yeah.
Thank you.
Okay, thank you. So yes, you ready?
Good afternoon. As stated, this was a repeat violator case. The current case number 18-800000391. The address is 1701 Mandalay Drive. It's a vacant lot. The property owner listed is the estate of Miss Irene Miller. The repeat violator case is from a 16 case, 16-800000351. In that case, were violations of City Code 8-40, 8-52, 12-1, and 13302. Exhibit number 1 going before the board are all the photographs to include the inspections. All of the notices to include the notice of violation and notice of hearing are exhibit number 2. Exhibit number 3 are my administrative docs, including the case summary, property appraiser, and tax collector records, as well as any emails associated with this case. Exhibit number 4 is the affidavit of posting and a copy of the sign. And exhibit number 5 is the affidavit of costs for this case. All the photographs and exhibits that were given to the violator are exact copies of what's being presented to this board. And all my notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations, notice of hearings were sent certified return receipt as well as first-class mail. And Madam Chairman, if you would, please accept all these exhibits into the record as evidence.
Yes, ma'am. Do you have any objection to the city's documents being
No,
put in?
I do not.
Okay, thank you. And please receive those into evidence, Michelle. Go ahead, sir.
This case started on June 8th of this year. My initial inspection, the lot's overgrown. It was previously mowed and established, as I stated, under the previous case in 2016. The vines are once again growing into the trees, causing potential damage to them. Trees along the western side are encroaching onto the neighbor's property. They happen to be Brazilian pepper trees. On that same date, June 8th, 2018, the repeat violator notice of hearing was mailed, certified as well as first class. Conducted a reinspection after we were notified that the property was in compliance. June 22nd. On June 28th, I did post the property for this code board, and we did get the repeat violator notice of hearing returned to us unsigned. We did have contact, I believe our clerk had contact with the lady that is here, actually from the maintenance manager, Joe, who said the property was ready to go, so he was aware of the notice. As I stated earlier, the previous case were violations of 8-40, 8-52, and 13302. Which are the same violations that occurred this time. 8-40, the duty to maintain private property. 8-52, which has to do with the nuisance conditions, which specifically deal with an overgrown lot. And 13302 has to deal with the maintenance of the trees, particularly the vines climbing up into causing damage to the regular trees. And as stated, it was in violation for a period of 14 days. As of right now, the property is in compliance.
Board have any questions for Officer Gasson?
He mentioned 12-1 earlier, I thought, and it wasn't on the list.
I was just referencing what the repeat violator case was for. That's not before the board today.
Thank you.
Any other questions? Ma'am, do you have any questions for Officer Gasson?
No, but I do get a chance to speak, do I not?
Yes, right
Okay.
now it's just questions.
No.
Okay, you can go ahead now and present your case.
I have been looking after this property for 42 years. And roughly about 15 years ago, I have no neighbors at all around this property except one man on the west side. He wanted the property. He wanted me to sell it to him. I told him no, that it was in our family and we wanted to keep it. That was it. From that day forward, this man calls code enforcement on me all the time. Now, I have a lawn service. This code enforcement told me every 6 weeks. This does look quite heavy, but my lawn man was there on the 10th. So the guy next door calls 2 days before it's to be mowed. And I know exactly what he was looking at if you look at the last picture, you see that little bit of Brazilian pepper hanging over on his lawn? That's why he calls. He calls all the time. I'll give you one example. There's many. I have many examples. It's spring. We went out, we trimmed, we mowed, okay? 2 days later, notice comes from the city. You cannot trim and cut things down and throw them on the lot. We don't do that. We pick it up and take it away to the yards. We go out there, and here along the west side, on the other side of the fence, is piles of refuse, piles. And I said to myself, any other time, which has been many times, people come and drive up to this lot and dump their yard goods. Why did somebody walk all the way back and carry this stuff back there and throw it? I stood there. I'm not an arborist and I'm not a code enforcement, but I looked at it. I looked up. The guy next door had cleared his whole yard, cut his bougainvillea. There the bougainvillea were laying. He cleared his Queen Anne palms. I don't have any Queen Anne palms or bougainvillea on my lot. There they are. There was tons of bahia grass, and you can see it right here in this last picture. That's what he has in his yard. All he did was walk up and throw it over the fence. And then he called code enforcement, and code enforcement told me I couldn't put that stuff there. I had to pay $215 for someone to go and pick it up and take it away. When I was here in 2016, I paid $1,800 for them to cut down the Brazilian pepper, which you can see is not, I see a lot of Brazilian pepper and tarpon. And the vines are growing on palm trees. I don't see them strangling anything, but suddenly they're killer vines. I paid $1,600 for that to be cleared up. This does look rough here, I have to admit, but I just paid $540 this last time for them to go out and cut that Brazilian pepper. Now, my lawn guy he doesn't work anymore, he's retired, but I got his name from code enforcement. He knows everything that has to be done. And you know what he says to me? You're being singled out. You know that? He says, I don't have to do that on my other lots, but yours has to be pristine. I said, I know. It's the guy next door. So he went to the guy next door and said, here's my card. Take it. He says, if you have any problems, call me. I'll come right out and I'll fix whatever needs to be fixed. Quit torturing this woman next door. And the guy slammed the door in his face. And that was just a couple, and then I know that it was quite a few days, but if within 2 days it was mowed and edged, okay? And then that same day I got with Mr. Renardo and we went and started calling. Now, you know, you call lawn guys in the summer and you know what they say to you? We're packed. I called that very day and we found someone, but he could not start for 3 days. And then he came out and worked on it for 3 days. And then Mr. Renardo went out and made sure that was in compliance. I'm not trying to get away with anything. I'm just saying I don't have a chance here. I keep it up. I've spent, within these last 2 years, that's $3,200 on a vacant lot. I've tried to talk to the man next door. Oh, he will not speak to me. So this is what I've decided to do. Even though this property has been in our family for 65 years, I went today to the lawyer and I'm going to start. Now we're going to have to sell it. I can't do this anymore. That's it.
All right.
And anytime, whatever he says has to be done, I have it done. But it's not enough. I can't go out there every day with a pair of scissors and trim everything for that guy next door. And I'm on a dead-end street, 2 dead-end streets. Less than 10 people see my lot. But yet it's a disaster. Something has to be done. That's it.
Board have any questions? Mr. Gasson, do you have any questions?
No, I
Dr.
don't.
Gasson?
I don't have any questions. Thank you, though.
Am I wrong to think that somebody can constantly call
You can't talk
Time?
anymore, huh? You've
one
already-
person? Oh, excuse me.
Do you have anything to summarize? Did I do that?
I'll do a really quick summary, and part of it's going to make a little statement. I have 4 active cases on your street right now, so you're far from being singled out. And I have currently 175 active cases in the city of Tarpon Springs. So with that being said, she's had numerous priors before, all the way back to 1999. So it's not by any stretch of the imagination a new thing. The lot was grossly overgrown, as she stated. It was pretty significant. For what it's worth, the gentleman that complained doesn't live next door. He lives farther down the street. So there's not a singling out issue. She is right on the corner, but that property is very noticeable because of that. There is a couple more houses being built on that same street. So people are very well aware of what's going on with it, and that's probably what's precipitated the complaints within the last couple of years. So I get her position and her understanding, but the fact is the lot was grossly overgrown. As we all are aware, it grows pretty fast down here. As far as timing goes, I can't tell you that. When I took the pictures, it was overgrown. It was outside of the city ordinance of allowable limits pretty significantly. And that's all I have.
Is there anything else you'd like to summarize?
Well, as being singled out, I've been here 41 years, and I can tell you that I have been called and gone to have to straighten out that lot. But yet when I go down the road, there were 2 monstrosities at the end of the road where they had all the building material left. The grass was up to the windows. There were no windows. All the insulation was flapping in the wind, and that was for years. But I had to have my lot mowed. Now, I don't give anybody any heat. You write me, and I go and I take care of everything. I have someone that comes every 6 weeks, like you told me. You told me have them come every 6 weeks to mow, and I did. And you're saying to me it's somebody down the street. Well, why would somebody down the street be worried about that little bit of Brazilian pepper hanging over that lot next door? I just don't know. Like I said, I went today, and I'm starting procedures to sell the property because I just can't keep up with this.
The public portion of this case is now closed, and we will entertain a motion.
I move based on testimony, evidence, facts presented in the law that the respondent was in violation of sections 8-40, 8-52, 133.02 of the Tarpon Springs City Code from the initial date of 6/8/2018 to the compliance date of, if I could read it, 6/22/2018, and a fine of $20 a day for 14 days, or total of $380. In addition, I move the city be awarded $76.50 for the costs incurred in prosecuting the case.
Second.
Any discussion? Roll call, please.
Ms. Norfleet? Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Vice Chair Weeks?
Yes.
Vice Chair Archer?
Yes.
So, Ms. Miller, I'm going to go ahead and summarize. The board has found the property owner in violation of those 3 codes, section 8-40, 8-52, 133.02. Although the board had the opportunity to fine up to $500 a day for each one of those days that it was in violation, the board has fined $20 a day for 14 days, a total fine of $380. The city has also been awarded its prosecution cost of $76.50. You can pay that directly to the city clerk's office. You'll receive an order within about 10 days. It will be mailed to the address listed by the tax collector and property appraiser's office. Do you understand that? Thank you.
Okay, number 15. repeat violator in violations from 6/9/18 to 6/10/18 for 1 day. The case number is 18-800000396 at 715 Dodecanese Boulevard, Joyce Pappas. See the rest of those? Is that Fenista,
Yeah.
Megan,
Living Trust.
Living Trust, and Fenista Megan,
Trustee.
trustee. Theodosis Francis. Please give your name and your relationship to the property.
Ted Francis, 1005 Rose Tree Lane, Tarpon Springs.
Are you going to be speaking, sir?
I said 1005, I'm sorry. 1005 Rose Tree Lane, Tarpon Springs. Yep.
And my name is George Meehan. I'm the son of Finitza Meehan, listed one of the co-owners of the property.
And you both been sworn in?
Yes.
Okay, do you have any objections to our documents and photos being put in for evidence?
No objections.
Thank you. This is a repeat violator case. As stated, it was a 1 day violation, and I'll explain why it's only 1 day here in my case. The previous case was 17-800000053, which deals with Appendix B, the Smart Code, Chapter 6, outdoor displays. Same thing before this board under case 18-800000396, the address being 715 Dodecanese Boulevard. The owner stated previously. Exhibit number 1, all the photos to include my inspections. Exhibit number 2 are all notices, include the notice of violation and notice of hearing. Exhibit number 3 are administrative docs, the property appraiser and tax collector records, and any emails. Exhibit number 4 is the affidavit of posting and a copy of the sign. And exhibit number 5 is the affidavit of prosecution costs. Madam Chairman, all the photographs and exhibits that were given to the violator are exact copies of what's being presented to this board. And all my notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearings are sent both certified return receipt as well as first class mail. And please accept all these exhibits into the record as evidence. City of Tarpon Springs has Smart Code, which deals with the outdoor display, particularly in the sponge dock area. There's a significant number of requirements. I believe there was some paperwork that went around to the board. What it basically states is, and what the violation was here, is you can't have any items hanging on the outside of buildings. You can't have items on racks in the doorways, particular or partially blocking those doorways. The racks must be, it says greater than 36 inches in height. That's a typographical error. It should be less than 36 inches in height in front of the business. There's some requirements that go with the Americans with Disabilities Act that you can't have anything within 18 inches of the door. There's some requirements that also go along with the National Fire Code. In particular, on this particular property, I was double sorry about that. This particular property on June 9th, when I inspected it for outdoor display violations on the sponge docks, I did discover items hanging on the outside of the building. There were items on racks in the doorway, partially blocking them, and there were racks that were greater than 36 inches in height. 36 inches in height. You can see that in the photographs. Because these are businesses, technically they're in compliance every night. They take all these displays inside. So it's not the same as mowing your yard or anything like that. So it's an interesting kind of a case. I never had an opportunity. I did go back a couple of times, and I never saw them in violation again other than that 1 day. So it's simply before the board for a 1 day violation. They were already established under another case. They're currently in compliance. Moving forward on June 14th, the repeat violator notice of hearing was mailed certified in first class. As I stated, on June 27th, I specifically conducted a reinspection, and they were in compliance during the day. And needless to say, I conduct these during business hours, so after hours, they're always going to be in compliance. Didn't get any return mail, and we did have some phone calls and office visits from tenants and the owners. As stated, the violation is Appendix B, Chapter 6, the outdoor display definition under the city's Smart Code. And as I also stated, they're currently, well, it could be in compliance as of today, but they were on my last inspection. And I have nothing further at this point.
Board have any questions for Officer Gasson? Sir, do you have any questions for Officer Gasson?
No questions.
You want to go ahead and state your case now? Yes, would you like to make a statement?
Hold the microphone in front of you so everyone can hear you.
Yeah. I'm going to let my nephew start first.
Just move it over.
As was stated, myself, my uncle, and our cousin have all gone to code enforcement about this hearing. I was told the best course of action was to show up at this meeting and sort of explain the situation, that the property is listed as an established violator. I only got involved in managing my mother's interest in the building in April because of some health concerns on her part. The building is jointly owned by Joyce Pappas, Ted Franzese, and my mother, Finitza Meehan. It's considered a single lot by the Pinellas County property appraiser, but there are two mailing addresses there that are operated as separate businesses, 713 and 715 Dodecanese. But according to Pinellas County, that is one lot, and the single lot or the combined lot is considered a established repeat violator. For the past 3 years, the same tenant was renting 713 and 715, but as of May 1st of this year, that tenant is now only operating their business at 713 Dodecanese, and we have a new tenant that's operating a business at 715 Dodecanese. So Mr. Franzese and I have met with our tenant located at 715 in light of getting this notice, and have given him copies of all of the code enforcement regulations, and he's explained that to all of his employees at this point. I'm just here today to clarify that the business operating at 715 has only been in existence since May 1st, and this citation or hearing is the first one that's been given to that entity. Unfortunately, just the way the county classifies the building, the current tenant is labeled as a repeat violator for the prior tenant that he obviously had no control over their actions. But as I've said, we've given him copies of all the regulations, and he said he'll comply with everything moving forward and not put any racks in the doorways or anything outside above 36 inches.
This is a new tenant, started May 1st, and we have spoken with him in detail. We've given him all the data that we have here. So I don't think we're going to have any problems. They complied immediately, took everything down. And what Mr. Meehan has said, I concur with. So we are well aware of the codes now. And we will be working with that. Take care of it.
So we're just here today to clarify that and ask you to take that into consideration as you proceed.
Okay. The board have any questions? Officer Gasson, do you have any questions?
No.
Would you like to summarize?
Real quick, as he stated, it is one parcel. The city cites owners. We don't particularly cite the tenants, so that's one reason why the notice goes to the owners. We dealt with this property, as he stated, a couple of years ago, and we had some weird issues with it because of the fact that there is one parcel with two addresses. So it's the parcel as the whole. Luckily, at that time, when it was established, it was a problem with both of the mailing addresses, i.e. one parcel. So, but it was the owners that were cited, and as you can appreciate, it's the repeat violator as the owner, not the tenant. And it was just for the one day because, as I stated, I never had an opportunity to go back down there and go any further with that. So that's all I have.
Okay. Do you have anything else you'd like to summarize?
No.
Okay, so this portion of the case is now closed, and now I'll entertain a motion.
Yeah, I'll do it. I move that based on testimony, evidence, facts presented in the law, that the respondent was in violation of of City Code APPB:CH6 of the Tarpon Springs City Code from the initial date of inspection 6/9/2018 until 6/10/2018, and a fine of $10 per day for 1 day, or a total fine of $10. In addition, I move the city be awarded $76.50 for the costs that incurred in prosecuting the case.
I second.
Any discussion? Roll call, please.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Vice Chair Weeks?
Yes.
Chair Archer?
Yes.
Can I summarize? Okay, so the property's been found in repeat violation again. The board has found and fined $10 for the 1 day of the violation. The board has also awarded the city its prosecution cost of $76.50. The total due is $86.50. And the order from the board will be issued within the next 10 days. It'll be provided to the property owners listed on the tax collector's roll. If you have any questions, you can contact Officer Gasson after the meeting today.
If I want to pay it before the 10 days, can I pay it?
Yes, you can pay it at the city clerk's office.
When?
My suggestion is you wait until tomorrow because the city clerk is here right now.
That's fine.
And so she won't be able to go over there to collect the money, so.
That's fine, but I want to bring up one thing. We have, the third owner who's not here gets this information and it is not available to us. So that puts us in a very difficult situation. So I'm not going to wait the 10 days for her to give us, if she will give it to us. But this has been going on for some years. So this is an internal issue that we're going to take care of.
Thank
But
you.
I just want the board to know that we were not notified in 2017 that we were brought under the established status. So for this time, and we never got that information. So I'm just letting you know that this is the issue we are facing. That's where I'm going to go in and pay it ahead of time.
Sir,
Thank you.
my suggestion to you is to contact the tax collector's office and make whatever appropriate changes that you need to make so that whatever notices that the code enforcement department has to send out, they comply with that. So that's where your change needs to be made.
Thank you, and I will.
Okay.
Thank
Have a good
you
day.
for coming in. Okay, we're going to go to number 8. Case number 18-8000393 to be established at 793 Dodecanese Boulevard, George Villas. Is that it wrong? Is there anyone here?
Is there anyone here in that case? Okay, if you could come down here, sir. Sir, were you sworn under oath earlier today?
No.
Okay, if you could just stand up, raise your right hand, and face the clerk.
You swear from the testimony you're given this proceeding is the truth, the whole truth, and nothing but the truth?
Thank you.
Would you please give us your name and your relationship to the property?
My name is Merlin Krutzik, and I am the owner of Direct Time Distributors, who is the tenant. So we're the tenant of the property.
Okay.
All right. Go ahead, sir. Oh, do you have any objections to our documents or photos being put in for evidence?
No.
Okay, thank you. Michelle, would you please receive those in evidence when you get them?
Thank you. This will be the second of the 3 sidewalk display cases that you guys are going to hear today. So case number 18-8000393, 793 Dodecanese Boulevard. The property address is listed as the owner being a George, I believe it's Billas, Billias. Exhibit number 1 before the board are all my photographs, include the inspections. Exhibit number 2 is the notices, my notice of violation and notice of hearing. Exhibit number 3, administrative docs, the case summary, property appraiser and tax collector database records, and any emails. Exhibit number 4 is the affidavit of posting and a copy of the sign. All the photographs and exhibits that were given to the violator are exact copies of what was presented to this board. All notices were mailed to the property owner of record based on the Pinellas County Property Appraiser and Tax Collector database. All my notice of violations and notice of hearing are sent both certified mail, return receipt, as well as first-class mail. And, Madam Chairman, I believe you already have, but please accept all these into the record as evidence. It's very similar to the previous case, so I can go into it. We have a significant number of ordinance under Appendix B, Chapter 6, dealing with the outdoor display of merchandise, as I stated before. There's some requirements. On June 8th, I conducted the initial inspection on a neighboring property. While checking for violations of the outdoor display, I found numerous at this particular address. There were numerous items hanging on the door. There's racks of clothing greater than 36 inches in height in front of the store. There were displays less than 18 inches from the sides of the door.
And then the displays, as I already stated. I spoke to the clerk at the time, and the items hanging on the door were removed. On June 13th, we sent the notice of violation, notice of hearing. Regardless, we were going to establish this property, whether there was compliance or not. Again, they come into compliance every night when they close up shop and take everything inside. I conducted a re-inspection on June 27th, and at that time, the property was in compliance. I conducted another inspection on July 11th, and the property was still in compliance. We have had some contact with the owners, and I believe the tenants who are here in the past. With that being said, the one particular tenant, I believe Gloria is here, I've had ad nauseum conversations about her outdoor displays. She's well aware of these ordinances, and this is a significant issue that obviously I'm here on 3 cases. We've gone back and forth numerous times about this. This is no mystery to her. I've provided this packet of paperwork to her, no less, and her tenants no less than 10 times. So unfortunately now I had to bring these cases before this board to be heard, and hopefully establishing them will prevent future occurrences of this board having to hear these cases. So at this point, I have nothing further.
Does the board have any questions for Officer Gasson?
I make just a brief statement. I probably was downtown that same day, and you couldn't hardly walk down the sidewalk. There was so many displays outside. And I think that's another issue. If somebody makes a misstep, that curb was a little high right along there, and the cars, they're supposed to be going 5 miles an hour, but they're not. So I think this is a good thing to look at. I love our sponge docks. I don't want to hurt them, but I think this is a good thing.
Anyone else? In a minute, ma'am. Anyone else? The display that's out in front, and you had a yardstick. Is it not supposed to be any higher than that yardstick?
That is correct. 36 inches a yardstick. And unfortunately, if you look at the pictures that went around, I do have one where I actually took a picture of a yardstick with the photograph. So I figured that was pretty, we had some measurement issues before Code Board before.
Okay, and then from the door?
From the door is 18 inches, and the reference is basically the door frame. You give them a little bit of latitude. There's all kinds of different construction of doors, but basically it's that opening that somebody can walk through. The 18 inches is related to the National Fire Code. It has to do with being able to egress the building in case there's a fire. If there's things inside that or near that entryway, they can get tangled up in it and can cause an issue. And that's why that falls under NFPA, the National Fire Prevention Association, I think. And then there's also ADA issues. We didn't have any ADA particular things. Those deal with how much sidewalk you have and size of doorways and things like that as well for handicap access. But that's the reason behind the 18 inches from the doorway.
What about going inside? I see stacks of clothing on hangers on each side of the door going in.
Unfortunately for me, this particular code deals with the outdoor. It's specifically defined as the outdoor display. I would reason to believe that maybe the fire inspector might have something, but I'm not a fire inspector, so I can't begin to tell you, but I would maybe refer that to him.
Okay. All right, thank you. Do you have any questions for Officer Gasson? Just questions at this time.
Oh, I don't have a question. I know he's right that he did come and speak to me, and okay,
but no questions? No questions?
Either one of you? Not a question, really. I just ordered the racks,
if you don't
and
have
I
any
have
questions,
changed
you
them.
can go ahead and state your case, ma'am. Go ahead and state your case.
Well, you know, he came by, and I did order racks because it's extremely low, and I didn't have any in my possession at the time. And I ordered them all, and as soon as I could, I got them up. These are not the right pictures now. I have all new racks up. And I actually took away one that he didn't even ask me to take away, so it would make that corner where you go by very easy. So I actually really narrowed it down way more than I even had to. So I was trying to come in compliance. I just had to order certain things to get them out. So I got them out as soon as I got. And I did talk to him last week. I saw him and I asked him to come by because I had gotten it all up. And so it wasn't like I was completely ignoring it. I took everything off the doors. I took the 18 inches right away by the back of the doors like he asked me. And I was trying to come in compliance. And now I am in. It's not even an inch over. So thank goodness for that. That's all I.
Do you have anything, sir?
I don't think so. I think that's pretty much it.
Okay. All right. The board have any questions? Officer Gaston, do you have any questions?
No, I do not.
Would you like to summarize?
I think we've covered it. Thank you.
Is there anything else you'd like? All right, so we'll close this portion of the case and call for a motion.
I move based on the testimony, evidence, facts presented in the law that at the time of the alleged violation, sections City Code Appendix B, Chapter 6 of the Code of Ordinances of the City of Tarpon Springs were in force and effect. At the time of the notice of violation, the respondents were in violation of said code sections. However, they are now in compliance.
Any discussion? Roll call.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Vice Chair Weeks?
Yes.
Chair Archer?
Yes.
You want me to summarize? So the board has found the property owner in violation of Appendix B, Chapter 6 of the City Code. It has now been established as a violation. Should another violation occur by the same property owner within a 5-year period of time, they'll be considered a repeat violator and could be fined up to $500 a day from the date of the inspection where the violation is found. So it's critically important to remain in compliance. If you have any other questions, you can ask Officer Gasson of the Code Enforcement Department tomorrow or sometime after this hearing. You'll get a copy of the order. Actually, the property owner will get a copy of the order within 10 days. Okay?
Thank you. Thank you. Thank you very much. Okay, number 3. 3? Yes. Case number 17-800000781 at 455 East Tarpon Avenue. And this is 455 Tarpon Avenue, LLC. Is there anyone
Hello.
who'd like to have a seat and state your name and your relationship to the property, please?
Yes, hello. My name is Carol Notias, and I am the owner's mother.
Thank you.
You're welcome.
Do you have any objections to documents and our photographs being put in for evidence?
No, I do not. At that time, that's how the property was.
All right.
However,
That's it. That's it. We'll be back to you. Thank you, Mr. Officer Gasson.
Thank you. Case 17-800000781, 455 East Tarpon Avenue is the property address, as you stated. 455 Tarpon Avenue, LLC is the property owner. Exhibit number 1, going before the board, are all my photographs to include the inspections. Exhibit number 2, my notices to include notice of violation and notice of hearing. Exhibit number 3 are the administrative docs to include case summary, property appraiser, tax collector records, and any emails related to this case. The affidavit of posting and a copy of the sign are exhibit number 4. All the photographs and exhibits that were given to the violator are exact copies of what's being presented to this board. All notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector database. All notice of violation and notice of hearings are sent certified return receipt as well as first-class mail. And please accept all these exhibits into the record as you've already asked as evidence. This case started out in December of last year, December 29th, 2017. Originally got a citizen complaint about the house being vacant. The lot was overgrown, trash and debris, particularly on the north side and the end of the drive under the carport. Trash cans in public view, construction material around the north side of the building. There was a remodel permit was applied for in July of 2016. Just kind of quickly give you what the basis of this case is going to end up with is going to kind of deal with that unfinished property. Most of the rest of it came into compliance as we moved along, but that's what started my case out. The building code requires a new permit if no work's being done within the last 6 months, and the property cannot be left in a state of partial construction. On December 29th, the notice of violation was mailed certified as well as first class. January 5th, we got another complaint about it being overgrown, but that was still an ongoing case. January 17th, I conducted a reinspection. The rear of the house was still in a partial state of construction, as you can see in the photographs, from that permit from 2016. At that time, in January, the lawn had been mowed, but there was still some debris under the carport near the end of that driveway on the north side, fence material and paint buckets, etc. Sent a final notice of violation January of this year, first class and return receipt.
On April 2nd, the building department recommended postponement of the inspection until she was able to come down over the summer to deal with the expired permit. We had actually scheduled this case for a previous one, and at the last minute rescheduled it to try to work through the issues with getting that addition legal, for lack of a better term. So on May 3rd through June 8th, apparently several different contractors went to the building department to look at plans. Apparently the owner plans on correcting the foundation and then the porch, so the scope of the project sounded like it got larger. I conducted my reinspection on June 13th. There was basically the only thing at that point in time was the unfinished structure. It had been mowed, the debris and trash had been cleaned up, so we're dealing with the partial state of construction, which falls under City Code 8-40 and its particular definitions that say no structure can be dilapidated or in a partial state of construction. There's no building code issues per se before this board. It is strictly the partial construction under 840. So I then posted the property on June 28th after sending a notice of hearing on June 18th. And I did conduct a final inspection yesterday, determined there was still no permit issued. The building is still partially constructed with the Tyvek wrap around it, and it's not sided and finished. We've had phone calls and some other conversations with the owner. As I stated, she's been into the building, or representatives have been into the building department to try to solve this issue. There are violations listed as the accumulation of trash and the nuisance prohibitions, but I'd put before the board that they're in compliance. So right now I have 8-40, which includes those subsequent definitions that deal with the dilapidated structure, and that's all, or I'm sorry, the partially constructed building that you saw in the photographs, which is that addition on the back side. So that's the only thing I have before the board is the fact that structure.
822, 852 are out
822 and 852 are off,
Okay.
and we're only have 840 before the board. And that's all I have at this point.
Board have any questions?
there. Yeah, what kind of, have you talked about timing to get this thing done?
I know prior to Vicky Russo leaving, she was kind of spearheading that whole thing, and then it just seemed to get to some weird stalemate. And then finally, with her leaving, we didn't know where else to go, and we hadn't, numerous contractors had come in, and I don't understand the reason why it hasn't gone any farther. So that's why I just simply brought the case before the board, and we've now been able to present a person that might be able to answer that question for you.
Beautiful.
Do you have any questions at this time for Officer Gaston?
No, I believe Officer Gaston
Okay.
has
No
done his
questions?
job.
Ma'am, just questions? No questions? Okay.
Pretty much he's answered
Okay,
everything.
you can go ahead and state your case then. Go ahead.
But he has asked one question about the construction, why it has not been done. I mean, that's what we're asking too, why it has not been done. We're dealing with a lot of contractors. I snapshotted from my phone conversations where they just say they're going to come, they don't come, they're going to send a proposal, they don't send the proposal. I've heard all excuses, children are sick, they're in the hospital, they're this, they're that. And I understand, but it's not that we're not doing anything. We want to do something, but you need also the contractor to do something. So if you're not working hand in hand, what are you going to do? Like, I have snapshots here of conversations. I'm getting estimates. Hopefully this project will finish. It will get done. 'Cause,
Unfortunately, all
we're the ones that
contractors
want
are
to do
busy.
it more than anyone. We wanted to start the back porch. It wasn't leveled. We wanted to level the floor. And then a contractor started the job. He did everything illegal, without plans, without permits, without anything. We were going to the building department asking them, has there been a permit pulled out? Have there been plans submitted? No. So now on top of that, we get reported in December 2017 by the previous owner that owned that home. And that's not right for us either, because, we buy a home, it's a beautiful home, it's all rotted, everything, electrical, windows, floors, termite bitten, destroyed. And now we're here, it's like I'm trying to find out what we've done wrong. And we want to get this done because it was our idea to knock it down. But that's what happened. Heavenly Foundation was hired, and the guy didn't do what he had to do. And now we're trying to work with contractors for someone to finally get the job and finish. So I don't know what else to say.
The board have any questions?
Yeah, what's your ultimate goal? What do you want to do with the property?
Excuse me?
What are you trying to do? What do you want to do with it?
What we're gonna do with the property? Actually, we're gonna have it as a vacation home. We're from New York. We are Greek. We love Tarpon Springs. And whenever, we wanna be coming down here. Winter time, whenever we can.
Any other
You
questions?
guys have any better plans, what we should
Any
do
other
with
questions
the
from the
property?
board? Officer Gaston, do you have any questions?
When did you buy that, or when did you guys acquire this property?
When was it purchased?
Yeah, when?
I believe 2012.
Okay. And you guys when did you start the construction project on it?
This particular one?
The
back
addition in the
porch?
back.
The back porch?
Yeah.
The back porch, I believe, started in August 2016.
You had stated that you had contacted the city because there was no permit, but there was a permit pulled.
I was going down and asking them if there was a permit, and they were telling me there was not a permit and there were not plans. He might have submitted the permit, but after. Because I remember Anthony had came out, he was pressuring the director, one Inspector Anthony, and he came out and he told me, I have a lot of pressure from your contractor, and I came down here to see myself what's happening. And I told him the job is not good, and for him not to pass it. And that's where we left it.
Have you discussed with anybody demolishing that and starting from scratch?
If it has to be done that way, it's preferable that we do it that way than just try to salvage what's there, because I don't know what's there.
Okay. I have no further questions.
Would you like to summarize?
No, I don't.
You have anything else you'd like to summarize, ma'am?
Not really. I just want this to finish. I want someone to get hired and to do what we have to do. Because everything else, like, we always pull out permits. We put windows in, we pulled out permits. We did the roof the same, the electrical the same. It's like, but it was our luck, and it happened.
Okay. Okay, the public portion of this case is now closed, and we will entertain a motion.
I move based on the testimony, evidence, and facts presented in law that at the time of the alleged violation, Section 8-40 of the Code of Ordinances of the City of Tarpon Springs was in force and in effect. The respondent was in violation thereof.
Have a second?
Second.
Any discussion?
Yeah, unfortunately for her, our economy is pretty good right now. Construction business is very good. Everybody I know in that business is busy. And the key is finding someone with a license who can get a permit, as we went through a few cases ago here about permitting. She's got a rock and a hard place here trying to find a contractor. I happen to know a GC. I will ask him.
Please.
But I think he's busy too. So.
I understand.
Okay. Roll call?
Ms. Norfleet?
Yes.
Mr. Robinson?
Yeah.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Vice Chair Weeks?
Yes.
Chair Archer?
Yes. Officer Gaston, do you have a recommendation for a time frame or for compliance or daily fine?
I almost wish I'd like to ask her, but I think under the circumstances, there's been a lot going on since December. I think we're at the point where, at best, we should probably be at 60 days, and she needs to make the decision of whether demolishing it. If she demolishes it, she's in compliance. If that addition is removed from the house, then she's in compliance, which sounds like maybe be her intent anyway. So I think 60 days is probably reasonable for that. Beyond that, $100 a day.
Do you have any input on the compliance
Can I
date?
please request more time than 60 days?
How much time do you think you need?
I would say 90, a month more. Because it's summertime, everyone's busy.
Okay, we'll take that into consideration. Okay, is the board ready to entertain a motion?
Thank you.
Welcome, ma'am.
I move that the respondent shall have until October 11th to bring the property into compliance with Code Section 8-40 or suffer a fine of $50 per day for each day thereafter the respondent remain in violation of said code sections.
Second.
It's 90 days, yeah.
Any discussion? Roll call?
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Downs?
Yes.
Vice Chair Weeks?
Yeah.
Chair Archer?
Yes.
Thank you.
Okay, so ma'am, I want to go ahead and summarize what the board has done. The board has found the property owner in violation of City Code Section 8-40. Property owner's been given until October 11th, 2018 to come into compliance. Should the property not be brought into compliance by that date, a $50 a day fine will begin to run. It's very important for you to get compliance on the property before that time. You'll have the order. It'll be provided within the next 10 days, and it'll be sent to the address listed by the tax collector and property appraiser's office. If you have any questions, you can contact the Code Enforcement Department after today.
Okay, thank you.
All right, thank you.
Thank you, ma'am.
Good luck.
Yes, yes. Okay, we're going to number 13. This is a repeat violator in violation from 6/6/18 to the present. It's case number 18-800000389 at 518 East Lime Street. And it's 518 East Lime Street Land Trust, Ann Wayne, DRE,
I give this to her.
No, I don't want you doing that.
Hilarco LLC.
Yeah,
Is
that's
there,
correct.
okay, ma'am, would you give
Trustee.
your name and your relationship to the property, please?
Eladia Bolito. I'm a managing member of Hilarco LLC, which together with Ann Ween individually, we are co-trustees to a land trust. The name of the land trust is the 518 East Lime Street Land Trust under trust dated June 27, 1996.
You okay with that? Thank you. Officer Gasson?
Thank you. As stated, this is a repeat violator case. It started on June 16th, still presently occurring. There's three prior repeat violator case numbers associated with this. The first one is case number 16-800000287, which were violations of 8-22 and 8-40. That's trash and failure to maintain private property. The second repeat violator case, there was 17-800000056. Also 822 and 840. At that time, there was a $75 a day fine rendered under that case number. Then under case number 17-800000632, also 822, 840, and 852, and a fine was rendered for $100 a day on that one. Those two prior cases were brought into compliance, but none of the fines have been paid yet on those two prior cases. Moving forward, as stated, the case is 518 East Lime Street. I think it's a threeplex apartment unit owned by 518 East Lime Street Land Trust, Ann Ween and Hilarco LLC. Exhibit number 1 are all the photographs to include the inspections. Exhibit number 2 are my notices to include the NOV and NOH, the notice of violation and notice of hearing. Administrative docs to include the case summary, property appraiser, and tax collector databases are exhibit number 3. Exhibit number 4 is the affidavit of posting and a copy of the sign. And exhibit number 5 is the affidavit of prosecution costs. All my photographs and exhibits that were given to the violator are exact copies of what's being presented to this board. All my notices were mailed to the property owner of record based on the Pinellas County Property Appraiser and Tax Collector databases, sent via first class and return receipt requested. And Madam Chairman, if you would please accept all these exhibits into the record as evidence.
I didn't ask.
Hold on a second, Steve.
Ma'am, I didn't ask you, are you okay with our documents and photos being put in for evidence?
For lack of additional information, I accept it at face.
Okay.
So treat that as a no objection.
Yeah, okay.
With
Michelle, would you
caveats.
please- okay. Would you please accept these?
This case started on June 6th of 2018. Major Trill with the police department and other officers were at the address assisting animal control. At that time, photographs were taken. The property was just covered with trash. And he then contacted me, and I started the case. On June 6th, the repeat violator notice of hearing was mailed certified as well as first class. On June 28th, they conducted a reinspection. There's still trash, shopping carts strewn around the property, and it's not in compliance. June 28th, they posted the property, and an affidavit was signed. On July 5th, management company was contacted to let them know the property was still not in compliance. We did get back the notice of hearing from the registered agent, and we have had phone contact with the management company, and currently before the board are violations of 8-22, accumulation of trash, 8-52, the nuisance prohibitions, which deal with debris and things like that, and then just 8-40, which is the requirement to maintain private property. And I have nothing further at this point, Madam Chairman.
Board have any questions?
I got confused when you said some things had been complied with from the previous repeat violation and some things had not been. Are those fines still ongoing for all three of these issues?
No, what happened was the two previous cases, they came into compliance after a period of time, and the fine was assessed by this board, but it had not yet been paid. So those fines are still outstanding, but they're not accruing daily because
Okay,
they're in.
but nobody paid for them the last time.
Apparently they. That's what I said. Yeah, they're in compliance, but the fines are no longer daily accruing. They're a stagnant fine of about
Still owe the
$5,300.
money, but it's not getting any bigger of a pile of it.
Well, it started on June 16th, so whatever this board decides, there's been fines accruing since then if you find it as a repeat violator.
Cross-examination.
Yeah, I was waiting to see if you had any. Anybody have any questions? You're waiting to see those? No questions? Ma'am, do you have any questions for Officer Gasson?
Well, I can cite at least 2 days that it was in compliance.
Just questions, ma'am. Do you have any questions for Officer, you wanted to ask Officer Gasson at this time?
No.
Okay. You want to go ahead and state your case then? Go ahead.
Microphone, please.
Hold the microphone in front of you so we can all hear you.
Yes. I do have an invoice dated July 6, 2018, for the contractor that cleaned the property on that date. So it was in compliance on that day. I don't know what happens from day to day. It is a problem property. I don't feel like, I feel like I'm the victim. I wish the city of Tarpon Springs, code enforcement, police department, solid waste could go after the true perpetrators, the dumpers, rather than me, the dumpee. In some jurisdictions, the solid waste will even paint the garbage to follow the trail to see where it begins and where it goes from there. And, often there are many objects within the debris that show other addresses from which the garbage has worked its way to the present location. And I've tried to come up with a solution. The only thing I can think of is security camera on the property to try to catch the perpetrators. But anyway, I do have an invoice dated July 6th. I can provide a copy of that. then I just received a copy of another invoice. It's on my phone because I got it on the way here, and it is dated July 6th. So presumably the property was in compliance on July 6th. Well, wait a minute. I think I repeated the name of a date. Okay. I'm sorry, May 3rd, which predates the citation of June 6th. Code Enforcement's June 6th citation followed this property being cleaned on May 3rd. And then again, it was cleaned on July 6th. And we found out that the problem tenant there in our Unit C was the perpetrator. And we have since, as of June 30th of 2018, we sent them a lease non-renewal notice, and they have a deadline of July 31st, 18 to leave the property, which they'll probably dump again. When they leave, they will leave a lot of debris behind, and we'll have to take care of it. But they are the most recent perpetrators of what's going on there. So I can provide you with that invoice that's dated May 3rd, which of course predates the citation, and then again with a copy of the invoice dated July 6th. And I can also provide a copy of that lease non-renewal notice for whatever good that may do. Those three items in the chronology of events.
Does the board have any questions? Officer Gasson, do you have any questions?
Yes, I do. Were you aware of the two previous cases and going before this code board and in 2017?
Yes, I was told by Ann Ween and the manager, Mike Shimshoni, that they were coming to a hearing, I think roughly a year ago. At that time, I could not attend because my husband was in the hospital.
Okay. Were you aware, did you see any of the notices that were provided by the city to you?
The only notices I received were after the fact, once the property was cited. Not any notices informing me of a problem that needed to be done subsequently.
So on one of those notices, did you happen to notice anything that referred to a repeat violator?
I have seen the term, yes. I have a copy of the this notice of hearing, which mandated my attendance.
Okay. When you got the invoice for the property being cleaned up on July 6th, did you contact code enforcement to do an inspection?
My understanding was that the management company was making those contacts.
Okay. I have no further questions.
Would you like to summarize?
Yeah, briefly, this property is even as the property owner stated, a problem property. It is a significant problem property in the city. This owner, Ann Ween, has 24 prior code enforcement cases. As I stated earlier, the two that were complied with but are in fine status as owing fines are just from last year: 2 and 16, 2 and 15, 14, 2 and 11, 2 and 8, 7, 5, going back on and on and on. You guys saw the photographs. It's the owner's responsibility to take care of the tenants. I'm not going to get into discussing how you manage your property, but ultimately we're here because the owners aren't taking care of their property, whether they're tenants or what. City of Tarpon Springs cites owners, doesn't cite tenants in these particular cases. So it is upon the owner and the fact that management company is supposed to do X or whatever. Ultimately, it's the owner's responsibility to take care of these properties, and that obviously isn't being done in this case. So I would ask the board to find it once again in violation of 8-22, 840, and 8-52, and still currently in violation.
Pam, do you have anything else you'd like to summarize?
Well, I'd like to go out there myself now and see if, in fact, the last time that it was supposed to be taken care of, July 6th, that the property is still clean, if there's more debris there. I understand there was even a boat there on July 6th that was removed. I need to drive by to see what the status is today.
So the public portion of this case is now closed, and we will entertain a motion.
I move that based on the testimony, evidence, facts presented, and law, that the respondent (518 East Lime Street Land Trust), Ann Ween,
Trustee.
LLC, was in violation of sections 8-22, 8-40, 8-52 of the code of the Tarpon Springs City Code from 6/6 of 2018 to the present, and until such time the property is brought into compliance, a fine of $250 per day shall be imposed until compliance is met. In addition, I move that the city be awarded $76.50 for the cost it incurred in prosecuting the case.
Second.
Any discussion? Roll call, please.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
No.
Vice Chair Weeks?
Yes.
And Chair Archer.
Yes. You want to?
Yeah, so ma'am, the property's been found in violation again. There is a fine running on the property beginning on June the 6th, and it's going to continue running on the property at $250 a day until the property is brought into compliance with the three-sided code sections 822, 840, and 852. The city has also been awarded prosecution costs of $76.50. The order will be entered and will be provided to the property owner listed by the tax collector's office within 10 days. And it's my advice to you is to get the property into compliance as quickly as possible. Call code enforcement so they can come out and do an inspection of your property. If you have any questions, you can contact the code enforcement department tomorrow or sometime after it's in compliance.
I have one remaining question. Should I provide those 3 exhibits that I referenced?
The case is closed now, and so the answer is no, you don't need to do that.
Okay.
Thank you.
We're going to 4?
Order.
In order now, right?
No, we're going in order.
Well, we've done 1, 2, and 3.
Mm-hmm.
So number 4.
Number 4.
Okay. Case number 18-800000275 at 1145 River Ridge Drive, Brandon and David Smith Gillespie. Anyone here for that? Okay. Ready for you?
Case 18-800000275, 1145 River Edge Drive. Brandon and David Smith Gillespie are the owners of this property. Exhibit number 1 are all the photographs to include the inspections. All my notices to include the notice of violation, notice of hearing are exhibit number 2. Exhibit number 3, administrative docs, property appraiser and tax collector records. Exhibit number 4 is the affidavit of posting and a copy of the sign. All my notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector Database. All notice of violations and notice of hearing are sent both first class and certified return receipt requested. And Madam Chairman, please accept these exhibits into the record as evidence.
Yes, we will.
This case started on May 10th of this year. Got a phone call from the HOA regarding a gray Dodge van parked in the driveway with no tags. I confirmed that the VIN number listed 1B4GP44R6TB459114 did not have a Florida tag listed, and it was not listed at that property. That property is vacant, and that property also is currently in fine status or on daily fines for a completely unrelated reason to a vehicle. I applied a 10-day sticker at that point in time on May, and that occurred on May 10th. On May 24th, I went back and conducted a reinspection. The vehicle was still in the driveway. At that point in time, we issued a notice of violation via certified mail and first class to the property owner of record. June 9th, conducted another reinspection. The vehicle still in the driveway. On June 12th, the notice of hearing was mailed, certified and first class. On June 28th, posted the property and signed the affidavit of posting. July 11th, I conducted a final inspection, and the vehicle's still there. We did get back the notice of violation. Returned, was unable to forward, have had no contact with the owner. And before the board is a violation of 40.00 for the abandoned vehicle, which you're required to have current tags or be operable or both. And it, at best, has no current tags. And that's all I have.
The board have any questions for Officer Gasson?
So nobody lives there? Somebody just left the car there?
That is correct. Nobody lives there. It's a vacant house.
No other questions? Would like to summarize, Officer Gasson?
No summary needed. Thank you.
Okay, so we'll close this portion and entertain a motion.
I move based on testimony, evidence, and facts presented and the law that at the time of the alleged violation of City Code 40-00 of the Code Ordinances of the City of Tarpon Springs was in force and effect, the respondent was in violation thereof.
I second.
Any discussion? Roll call?
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Vice Chair Weeks?
Yes.
Chair Archer?
Yes. And you have any recommendation for time frame or daily fine?
I would say 10 days and $200 a day.
And that fine's going to the owner that doesn't live there?
Owner of the property. Correct. They live in town.
Oh, okay.
Okay, we need a motion.
I move that the respondent shall have until July 22nd, excuse me, that's a Sunday, 23rd, to bring the property into compliance with Code Section 8-40-00, or suffer a fine of $100 per day for each day thereafter that the respondents remain in violation of said code section.
Second.
Discussion? Roll call?
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Vice Chair Weeks?
Yes.
Chair Archer?
Yes. Okay, number 6. Case number 18-800000297. This is to be established at 438 Riverside Drive. John and Stella Merritt. Is anyone here for them?
So they're still waiting?
I don't know.
Could be fine reductions.
Yeah. Okay, Officer Gasson.
Sorry. Are we ready?
Whoops.
I was trying to kill my laptop. 18-800000297. The address is 438 Riverside Drive. John and Stella Merritt are the listed property owners. This case is before the board to be established. It's currently in compliance. Exhibit number 1 of the photographs include my inspections. My notices and notice of violation and notice of hearings are exhibit number 2. Exhibit number 3, administrative docs, case summary, property appraiser, and tax collector records, and any related emails. Exhibit number 4 is the affidavit of posting and a copy of the sign. All my notices were mailed to the property owner of record as determined by the property or the Pinellas County tax collector and property appraiser. All notice of violations and notice of hearings are sent via certified mail return receipt as well as first class. And Madam Chairman, if you would please accept the exhibits into the record as evidence.
Yes.
Case started May 8th. My initial inspection was, as you can see in the photographs that went around, there's a boat parked between the houses on the east side. It's less than 2 feet from the property line. We've had dealt with this property related to boat issues before, but there was a change of name on the property. One of them is still kind of the same, but we decided that not to use the repeat violator case and just basically start anew. City Code 42.00, parking of recreational vehicles in residential areas, does allow you to park in what's considered the inside side yard, which is on the side of a house, as long as it's beyond the front of the house. But with that being said, you can't park within 2 feet of the property line along the side of the house. And as you can see in the photograph, it's almost touching the neighbor's house. I had received a previous call from the neighbor complaining about this previously, and when I got out there, it wasn't an issue. And that neighbor had showed me their survey, and at that point in time, I was able to determine it. You can't see it in the photograph, but there's a dividing fence, and it's about 3 feet over the side. I've had no testimony, or nobody's presented anything to me that the other property owner to the east or to the right side in the picture has given them consent. So at this point in time,
I went ahead and wrote the violation up to be established. As I stated, we've had some significant problems with the way boats have been parked on that property in the past. But because of that ownership change, it's not a repeat violator case. So that's why it's before the board to be established again, because I have the odd feeling we'll be revisiting this property again in the future. As of this point in time, the boat's been moved and they are no longer in violation. So, give you the rest of the dates. On May 8th, we sent a repeat violator notice of hearing, but then we discovered we backed that off and just did it strictly as a notice of violation and a notice of hearing, which was mailed later on June 12th. I did conduct a reinspection on June 28th, and that's when the boat, I noticed it had been removed. And as I stated, I was still going to bring it before this board to be established. On June 28th, I also posted the property and signed the affidavit. We did get a notice of violation and the notice of hearing returned to us, signed by the property owner. We've had no contact other than those returned green cards from the property owner. So what's before the board right now is a violation of City Code 42.00, parking of recreational vehicles. And as I stated, they're currently in compliance, just to be established. And that's all I have, Madam Chairman.
Board have any questions for Officer Gasson? Anything to summarize, Officer Gasson?
I have no summary, ma'am. Thanks.
Any motion?
I move based on the testimony, evidence, facts presented in the law, that at the time of the alleged violation, sections 42.00 of the Code of Ordinances of the City of Tarpon Spring were in full force and effect. At the time of the notice of violation, the respondents were in violation of said such codes. However, they're now in compliance.
Need a second?
Second.
Any discussion? Roll call?
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Vice Chair Weeks?
Yes.
Chair Archer?
Yes. You have a recommendation for,
It's in compliance.
is in compliance, never mind.
Yeah, it's in compliance.
So we don't
I have
have
no
anything else on
recommendation.
that case? We can move on to the next one.
Okay,
Okay.
on to the next one. Number 7. Case number 18-800000351 at 711 North Diston for Barbara Beals. No one's here. Oh, yes.
Case number 18-800000351, 711 North Diston Avenue. Property owners listed as Barbara Beals. Exhibit number 1 going before the board with my photographs to include my inspections. My notices, my notice of violation and notice of hearing are exhibit number 2. My administrative documents, the case summary, property appraiser, and tax collector records, and any emails are exhibit number 3. And the affidavit of posting and a copy of the sign is exhibit number 4. All my notices were mailed to the property owner of record based on the Pinellas County Property Appraiser and Tax Collector database. All notice of violations and notice of hearings are sent via certified mail, return receipt, as well as first class. And Madam Chairman, please accept these into the record.
Yes, sir.
711 North Diston Avenue started out again as a police complaint. We had, I believe, a couple of arrest warrants out of there, some drug activity and some other things. At that point in time, I conducted my inspection on June 2nd. There was trash and debris all over the property, tires, items covered up with tarps, outside storage, shopping carts, piles of tree debris, old fencing, unregistered vehicle in the front yard. Yard's not being maintained, it's overgrown. The trash cans are left curbside and visible to the public. On June 7th, the notice of violation, notice of hearing was mailed, certified, as well as first class. On June 28th, I posted the property because my intent was, regardless of its state, based on the significant number of priors, I was going to establish this property regardless of compliance. On July 7th, I conducted a reinspection, as well as July 11th. The property's still not mowed, particularly on the north side. A lot of the trash had been cleaned up. The vehicle had been removed. Apparently, the owner advised us they evicted all of the tenants. So I believe, as of right now, I think there's only one person living in it. There is still a pile of debris in the backyard. The last photograph going around from exhibit number 1 shows it's going to be through the chain link fence when you see it, and it's a pile of debris and some other trash piled up behind the house. I don't have a picture showing. What you're looking at is to the east, so to the left is the north side of the house, and to the right's the south side. The south side is still grossly overgrown when I did the inspection, looking at it from the street, which is distant. So they're not in compliance as of right now for sections 8-22 or 8-52. They are in compliance under 816, 8-40, and 40.00. So the only thing before the board is 822 and 852. And Madam Chairman, that's all I have at this time.
Do you want those others established? And how-
Certainly. Yes, that'd be fine. Can establish the other three.
Is there any other questions for Officer Gaston? Want me to wait?
I'm gonna make,
You have
I'm
anything
gonna
else?
do the
I have
establishing,
nothing else.
Go ahead.
the ones that are in compliance. I move based on testimony, evidence, facts presented in the law that at the time of the alleged violation, sections 8-16, 8-40, and 40.00 sections of the Code of Ordinances of the City of Tarpon Springs was in force and effect at the time of the notice of violation. The respondents were in violation. However, they are now in compliance.
Have a second?
Second.
Discussion? Roll call?
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Vice Chair Weeks?
Yes.
Chair Archer?
Yes. You want to go over the other?
Then I'll do the other parts of that. I move based on testimony, evidence, and facts presented in law that at the time of the alleged violation, sections 8-22 and 8-52 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. The respondents were in violation.
Second.
Any discussion? Roll call, please.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Vice Chair Weeks?
Yes.
Chair Archer?
Yes.
There are 21 prior cases at this address spanning 18 years. Since 2013, there's 7 prior cases. The majority of them have to deal with accumulation of trash and fences and vehicles. So based on that, and you know, we started this case in June. I would say they did evict them, but I would give them 30 days and $150 a day.
I move that the respondent shall have until August 13th to bring the property into compliance with code sections 8-22 and 8-52, or suffer a fine of $200 per day for each day thereafter. The respondents remain in violation of said code section.
Second.
Discussion? Roll call, please.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Vice Chair Weeks?
Yes.
Chair Archer?
Yes. Number 9. Case number 18-800000394. This is to be established at 765 Dodecanese Boulevard, Gianeskis and Associates, Inc.
Thank you. Exhibit number 1, or I'm sorry, case number 18-800000394, address 765 Dodecanese Boulevard, Gianeskis and Associates. This is another outdoor display case. This will be the last one for today. Exhibit number 1 are all my photographs to include the inspections. My notices, notice of violation and notice of hearing are exhibit number 2. Exhibit number 3, the administrative docs, case summary, property appraiser, and tax collector records, and any emails related to this case. The affidavit of posting and a copy of the sign are exhibit number 4. My notices were all mailed to property appraiser or property owner of record based on the Pinellas County property appraiser and tax collector. All notices of violation and notice of hearings are sent certified mail return receipt as well as first class. And Madam Chairman, please accept these into the record as evidence.
Yes, sir.
As I stated, and I can refresh everybody's memory, but I think we have a pretty good grasp on the outdoor display now. June 9th, I was conducting inspections down on the sponge docks. There were numerous items hanging on the door, racks of clothing greater than 36 inches in height in front of the store. There were displays less than 18 inches from the side of the door, and at that point in time, we, on June 14th, I issued the notice of violation. You can see in the photograph, this particular one is not that bad. Primarily, they had the items hanging from the door. This one is interesting because it has sliding glass doors, and this is what I was talking about. It's kind of hard. There's not a strict definition. It just says from the doorway. So what I based the 18 inches on was if you had those doors fully extended to their open position, that would be the doorway. In this particular case, they were partially closed. They actually expanded those out for me, and they took off the items that were hanging from the door handles. And she cleaned the property up at that time, so she was basically in violation for about an hour after I had the discussion. But I've had this discussion with this property previously. On June 27th, I conducted the reinspection, advised her, I actually met with the tenant, advised her I was still going to have this property established, and she was in compliance. On June 28th, I posted the property, and as I stated, I had contact with the tenant, not particularly the owner. So I would like the board to establish the property for a violation of Appendix B, Chapter 6, defining the outdoor display in the Sponge Docks area. And that's all I have, Madam Chairman.
Any questions for Officer Gasson? Summary, Officer Gasson?
I have nothing further.
I'll entertain a motion.
I move based on testimony, evidence, facts presented in law that at the time of the alleged violation, Section City Code, Appendix B, Chapter 6 of the Code of Ordinances of the City of Tarpon Springs was enforced in effect. At the time of the notice of violation, the respondents were in violation of said code sections. However, they are now in compliance.
Second.
Any discussion? Roll call.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Vice Chair Weeks?
Yes.
Chair Archer?
Yes. Case number 18-8000402 to be established, 84 Burton Place, David and Rebecca Mitchell.
These next three cases, they're all neighboring properties that are vacant lots along Burton Place, which is down by Tarpon Turtle. So there's going to be a little bit of repetitive, but when you look at the photographs, they're kind of taken of all three properties at the same time. So I just wanted to let the board kind of understand when you look at the next two photographs, they're mysteriously the same as the other ones. So it kind of encompassed all three properties, all three lots of land. This particular lot, 84 Burton Place, is owned by David and Rebecca Mitchell. It's a vacant lot on Burton Place. Exhibit number 1 are all my photographs to include the inspection. My notices, violation and notice of hearing are Exhibit 2. Administrative documents, property appraiser and tax collector records. And Exhibit number 4 is the affidavit of posting. All the notices were mailed to the property owner of record based on Pinellas County property appraiser and tax collector databases. All the notice of violations and notice of hearing are sent certified mail, return receipt, as well as first class. And please accept them into the record as evidence, Madam Chairman.
Yes.
This is before the board to be established. Currently, it is in compliance. As I stated, it's a vacant lot over on Burton Place, which is a street that runs north and south north of the Tarpon Turtle, right by the lake. I got a complaint about all three of the properties being overgrown. Upon my inspection, it was overgrown. It was greater than 12 inches in violation of City Code 8-52. At that point in time, based on some priors, we determined we were going to establish this property. So, and moving forward, hopefully they'll take care of it themselves. On June 28th, I conducted a reinspection, and the whole property, which happens to be greater than 10,000 square feet, was completely mowed. I posted the property also on June 28th. I have no contact with the owner and have not gotten any of the mail back. So what's before the board right now is a violation of 8-52, basically the lot mowing requirements. And as I stated, it is currently in compliance. And I have nothing further, Madam Chair.
Any questions for Officer Gasson? Okay, we'll entertain a motion.
I move based on the testimony, evidence, facts presented in law that at the time of the alleged violations, Section 8-52, the Code of Ordinances of the City of Tarpon Springs was in full effect, force and effect. At the time of the notice of violation, the respondents were in violation of said code. However, they are now in compliance.
Second.
Discussion? Roll call.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Vice Chair Weeks?
Yes.
Chair Archer?
Yes. Okay, case number 18-800000403 at 1458 Mayor Lane Investments LLC.
Case number 18-8000403, 1458 Meyer Lane Investments LLC is the property owner. Again, this is the middle of the three lots along Burton Place, but it's got a Meyer Lane address. Exhibit number 1 of the photographs, exhibit number 2, notice of violation and notice of hearing. Administrative docs, property appraiser and tax collector records are exhibit number 3. An affidavit of posting and a copy of the sign is exhibit number 4. All my notices were mailed to the property owner of record, determined by the Pinellas County property appraiser and tax collector. All my notice of violations and notice of hearing are sent certified return receipt as well as first class. And Madam Chairman, please accept these into the record.
Yes.
June 14th, 2018, conducting the inspection on the property as well as the other two. It was overgrown. Again, establishing this one based on some priors. On June 18th, the notice of violation, notice of hearing were mailed, certified return receipt as well as first class. June 28th, conducted the reinspection. Again, this lot's greater than 10,000 square feet and it was completely mowed. On June 28th, I posted the property and signed the affidavit of posting. I've had no contact with the owner and none of our mail was received in the office. As I stated, 8-52, which deals with the requirement for lot mowing, they're currently in compliance, and that's all I have.
Any questions for Officer Gasson?
You said they're currently in compliance?
They are in compliance, yes.
Okay.
So it's to be established.
Okay.
You have a motion?
I move based on the testimony, evidence, facts presented in the law that at the time of the alleged violations, sections 8-52 of the Code of Ordinances of the City of Tarpon Springs was in full force and effect. At the time of the notice of violation, the respondents were in violation of said code section. However, they are now in compliance.
Have a second?
Second.
Any discussion? Roll call?
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Vice Chair Weeks?
Yes.
Chair Archer?
Yes. All right, case number 18-800000404 to be established at 60 Burton Place, Mayor Lane Investments LLC.
18-800000404, the property address is 60 Burton Place. Meyer Lane Investments LLC is the property owner. Exhibit number 1, again, and photographs include the inspection. My notice of violation and notice of hearing are exhibit number 2. Exhibit number 3 are property appraiser and tax collector records as well as the case summary. And exhibit number 4 is the affidavit of posting and a copy of the sign. All my notices are mailed to the property owner of record as determined by Pinellas County property appraiser and tax collector databases. All the notice of violations and notice of hearings are sent via certified return receipt as well as first class mail. And Madam Chairman, please accept these exhibits into the record as evidence.
Yes.
Again, this is the last of the 3 properties along Burton Place. On June 14th, conducting the inspection, the lot was overgrown in violation of City Ordinance 8-52 by nature of the fact that it's greater than 12 inches in height. The property is greater than 10,000 square feet. On June 18th, notice of violation and notice of hearing were mailed certified as well as first class. Conducted the reinspection and posted the property on June 28th. And again, this greater than 10,000 square foot property was completely mowed. No contact with the owner, no mail returned, and currently the property, as stated, is in compliance of City Ordinance 8-52, but I would like to establish this case due to priors. And I have nothing further.
Any questions for Officer Gasson? You have a motion?
I move based on the testimony, evidence, facts presented in the law that at the time of the alleged violation, section 8-52 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. At the time of the notice of violation, the respondents were in violation of said code sections. However, they are now in compliance.
Okay. Ms. Dabbs seconded?
Yes.
Yeah.
Okay, any discussion? Roll call?
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Vice Chair Weeks?
Yes.
Chair Archer?
Yes. Number 16, repeat violator, in violation from 6/27/18 till 7/10/18 10/18 for 13 days. 18-800000424, BLE of 523 West Cedar, Stanley and Demetrius Kavoris. Oh, yeah. So is that with everybody?
You ready? I'm sorry.
Go ahead.
Okay. 18-8000424. It's a vacant lot east of 523 West Cedar. The city hasn't assigned an address to the parcel, which is parcel number 122715736740000070. It was a repeat violator from a case in 2017, which was case 17-800000468, which was a violation of City Code sections 8-40 and 852. At that time, this board had assessed a fine of $100 a day to be in compliance, and they currently are in compliance, but they hadn't paid their fines as of yet, or fees as of yet. This case started out, I'm sorry, exhibit number 1 are all my photographs, include the inspections. All my notices of violation and notice of hearings are exhibit number 2. Administrative docs, case summary, property appraiser, and tax collector records, and any emails are exhibit number 3. Exhibit number 4 is the affidavit of posting and a copy of the sign, and exhibit number 5 is the affidavit of prosecution costs. All my notices were mailed to the property owner of record, determined by the Pinellas County property appraiser and tax collector. All my notice of violations and notice of hearings are sent certified return receipt as well as first class. First class. And will you please accept these into the record as evidence?
Yes, sir.
This case started out on June 27th based on a neighbor complaint, the lot being overgrown and not being maintained. It is a vacant lot that is less than 10,000 square feet, so the requirement to completely mow and trim it is in place. It was previously completely mowed in the 2017 case, 17-468. On June 27th, we sent the repeat violator notice of hearing, and on June 28th, I posted the property and signed the affidavit. I conducted a reinspection on July 12th, and it was in compliance. And we had received a phone call from the owner stating that they had got it in compliance on July 10th. So although my inspection was on July 12th, we're backdating it to the time they stated they had taken care of it, which was July 10th. So before the board is a repeat violation for a period of 13 days, June 27th to July 10th. And the violations of 8-40 and 852 are currently in compliance. And that's all I have at this time.
Any questions for Officer Gasson?
I did. Previously, they were fined $100 a day, and yet they didn't comply.
Previously, they were fined $100 a day, and it appears that they simply hadn't paid their affidavit of costs. But the city clerk would have to confirm that at a later time. But our records only indicate that they didn't end up with a running daily fine, but the board had ordered it, gave them a period of time to comply, and they came into compliance before any fines were assessed, but they just had the affidavit of prosecution costs.
And they are currently in compliance.
They currently are in compliance, yes, as of July 10th.
Okay, so entertain a motion.
I move based on testimony, evidence, facts presented in law that Stanley Demetrios Kavouras was in violation of sections 8-40 and 8-52 of the Code of the City of Tarpon Springs from June 27th to July 10th of this year. That's a period of 13 days. And a fine of $150 per day for 13 days. In addition, I move that the city be awarded $76.50 for the costs it incurred in prosecuting the case.
Need a second?
Second.
Discussion? Roll call?
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dobbs?
Yes.
Vice Chair Weeks?
Yes.
Chair Archer?
Yes. Now we'll go to the affidavits of noncompliance. We'll have to do those one at a time, so. 18-8000004 29 at 126 East Boyer Street, Sierra Wholesale LLC.
Anyone here for that case? Okay.
Thing, Officer Gaston, or
I have nothing to add to that.
just need a motion then? I want to make a motion?
So this would just be a motion to accept the affidavit of noncompliance and award the prosecution costs that are listed.
I move based on the testimony, evidence, and facts presented in law that the respondent failed to timely comply with the board's prior order within the time prescribed and to award the city $169 for the costs incurred in prosecuting the case.
Second.
Any discussion? Roll call.
Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Vice Chair Weeks?
Yes.
Chair Archer?
Yes. Case number 18-800000181 at 445 East Martin Luther King Jr. Carrington Mortgage Loan Trust, Wells Fargo. Lender is Legal Services LLC.
Anyone here for that case?
Okay, motion?
I move based on the testimony, evidence, and facts presented in law that the respondent failed to timely comply with this board's prior order within the time prescribed and to award the city $127.50 for the costs incurred in prosecuting the case.
Need a second?
I second.
Discussion? Roll call.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Vice Chair Weeks?
Yes.
Chair Archer?
Yes. Okay, now affidavits of compliance. What do we have? 1, 2. Can I do those two together?
Yes,
That
you can do the
don't have-
two without the prosecution costs together. That would be 19 and 21 if someone wants to make that motion.
Yeah.
I move we accept the affidavit of noncompliance in case number 17800000582 and in case number 18-800000029.
And those were, it was an affidavit of compliance, not non-compliance.
I'm sorry,
Of compliance.
I'm looking at right at compliance here and I said it wrong. Of compliance.
Need a second?
I second.
All in favor?
You can
All
do
in
it, please.
favor, say aye.
Aye.
All in favor?
Aye.
Aye.
Okay, we need you guys to respond, so
Yeah.
we can move on.
Okay.
Case 20.
Case number 17-800000708 at 814 Lincoln Avenue, Frida Ingram.
I move we accept the affidavit of compliance and award the city $142 for costs it incurred prosecuting the case.
Need a second?
I second.
Discussion? Roll call?
I'm sorry, who seconded that?
I did.
Okay, thank you.
Do I need a roll call on that, or?
It would be, since you're awarding costs.
Yeah. Roll call, Michelle. Oh, are they here for that?
Are you here in this case?
Yes, I am.
Are you disputing that the fact that the property is in compliance?
Yes.
No, I'm just, I know it's in compliance. My question is, like I noticed the cost of the affidavit fees varies. I just want to know what determines the cost of the affidavit fee. I see some varies. Like ours is 142, and I see some 127.50, 171. I'm just curious about how do you come up with the
Okay, so I'm going to try to summarize it then. So, sir, what is your name again?
My name is Nantes Harris.
Okay, and you're what relation to Miss Ingram?
My mother.
Okay, and so the question, Officer Gaston, was how was it determined that the prosecution costs are $142 in this case?
I'm getting to the affidavit. And
Okay, all right. So he'll be able to answer your question, but we need to move on after that.
How many things they make
Give me just a second, sorry.
cost copy.
Do you want to get it back? Yeah. If it's easier for you. Michelle?
I don't have that one.
Okay, so it's coming down the pike here.
Okay.
Based on my hourly rate, there were 2 inspections conducted. That's a cost of at $29 an hour, so that's $58 for the 2 inspections. The clerical time preparing the case and everything, the hourly rate's $15 an hour. There were approximately 3 hours spent preparing everything related to all the notices and everything, which total up to $45. The notice of violations, there's a $3 charge for those. The notice of hearing is $4.50. Basically, that's the amount of the paperwork and so on and so forth. There's materials. It costs approximately $8 to send to mail items via certified mail return receipt, which we're legally required to do. That was done 3 times for a total cost of $24. And our signs that are put in the yard, they're $5, so there was a cost of $5. All told, that adds up to $142. So that's how much it costs the city to basically bring that case to the code board administratively. So they're administrative costs, more or less, or costs of prosecution. Does that answer your question?
Yes.
Okay, so we can move forward on this case then. My suggestion, since we had affidavit, we have got prosecution costs, we do it by, not by a voice vote, but by a roll call vote.
Okay. And didn't we have a motion and
You
a
have a
second on
motion and a
that?
second
So you
on
can
the
go with the roll call.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Vice Chair Weeks?
Yes.
Chair Archer?
Yes. Case number 18-8000089 at 624 North Avenue, MNSF 2W1 LLC.
I move we accept the affidavit of compliance and to award the city $171 for costs that incurred in prosecuting the case.
Second.
Any discussion? Roll call?
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Ms. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Vice Chair Weeks?
Yes.
Vice Chair Archer?
Yes. Case number 18-800000227 at 1700 Blue Lake Court, Pamela Tro.
I move we accept the affidavit of compliance and award the city $127.50 for the costs that incurred in prosecuting the case.
Second.
Any discussion? Roll call?
Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Mr. Kramer?
Say yes.
Calling for
Yeah,
a vote.
yes, I'm sorry, okay.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Vice Chair Weeks?
Yes.
Chair Archer?
Yes. Case number 18-800000241 at 80 West Park Street, Constantinos Scaris.
I move to accept the affidavit of compliance and to award the city $120.50 for the costs that incurred in prosecuting the case.
Second.
Any discussion? Roll call?
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Vice Chair Weeks?
Yes.
Chair Archer?
Yes. Number old business, we have a fine reduction request, 15-800000626 at 1098 South Pinellas Avenue, Juniper Development LLC.
Okay. So, sir, you understand that this is being done totally by the written petition. If the board has any questions for you, they'll ask you to step forward. You can come down here to save time if you want, if they have any questions, but otherwise, they're going to make their decision based solely upon the written petition.
That's my thing.
Oh.
Old business. The board have any, has the board had an opportunity to read the petition? And if you have, we're ready to entertain a motion.
That's the original. It needs to be passed out to the clerk.
Here. Anybody ready for a motion?
Yeah, if we could find the right motion.
the last one.
Last one.
That's what I thought. But motion of fine reduction?
Yeah. Michelle, do you have a calculation as to how much is due on this one?
Sure, $71,400.
$71,400, thank you.
The fine ran from March 4th, 2016 at $100 a day until compliance date of February 14th, 2018.
I move that the fine of $71,400 in the case 15-800000626 stand. Right. Thank you.
Second?
Second.
Do we have any discussion on it?
So this is to deny the affidavit for
That's
request for
correct.
reduction of fine, okay. That was Mr. Vice Chair Weeks and Mr. Robinson?
Yeah.
Correct.
Thank you.
And do we have any discussion? Call for the vote.
Ms. Norfleet?
Let me just make it clear. This is a motion to deny the request. Okay, so her vote was aye.
Yes, okay. Mr. Robinson?
Yes.
Mr. Kramer?
No.
Ms. Wade?
Yes.
Ms. Dabbs?
No.
Vice Chair Weeks?
Yes.
Chair Archer?
We're denying the request?
Yes.
Yes.
Okay, so it was a 5-2 vote. The motion passed. The request for fine reduction has been denied. So we're in the last case.
Case number 18-800000029 at 126 East Boyer Street, Sierra Wholesale LLC.
Michelle, what is the outstanding?
The outstanding fine, there is a fine amount due of $250 and a prosecution cost that was awarded $169 for an outstanding amount of $419.
And were we given a copy of their request for reduction?
Yeah.
It's in that.
In your
In our packet, yeah.
I can pass you down mine. It looks like this.
Brown on it?
Yeah, I don't.
Okay, can you pass it down?
I've been
Ignore my
looking the whole
notes. I was
day
just
for-
making note of what the fine amount was in the upper right-hand corner.
I can
Okay, and Becky, that's the original. These go to the clerk.
Yeah.
Pass it down to the clerk.
All right.
Okay.
Yeah.
Are we ready for a motion?
I make a motion that we refuse the fine reduction in case number 18800000029.
What's the motion to deny the fine reduction request?
That's correct.
Thank you. Second.
Any discussion? Roll call.
Ms. Norfleet?
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
No.
Vice Chair Weeks?
Yes.
Chair Archer?
All this paperwork.
You need to respond. Aye.
Yes.
Other affidavit.
Motion carried.
We don't have any.
So you lost your
We don't have any minutes, right?
No.
I just had that. Any public comments? Any city comments, staff comments?
Yeah, I want to let you, let the board know, moving forward, we created a new notice of hearing that deals specifically with solicitors on the sponge docks.
Will you talk in the mic?
I certainly can. I thought my voice carried well enough.
Get my hearing aids.
We created new notice of hearings that deal specifically with solicitors on the sponge docks. In the past, what would happen is I'd write them a notice to appear into circuit court, and they would be heard by a district court judge. We would prefer to have those cases heard by this board and kept within the city. So with the help of the city attorney's office, we've created a notice of hearing. What basically will happen is a person will be issued this notice of hearing for a particular violation solicitation, and they'll be given a hearing date, and they will come down here, and you will hear that case. I just wanted to let you guys know that this will probably be occurring in the near future, probably within the next couple of months, and it is different than what we've done in the past with notices. And then that brings up one question I just have for Mr. Trask is, do we have to post the notices at City Hall for the solicitors on the sponge docks for that?
We need to do it exactly the same way that we do for a regular code enforcement case.
Just the fact that that's their notice of violation and notice of hearing. Okay. So, like I said, if you have any questions, I don't know if this is the appropriate time to go through it, or if we, but I just wanted to bring that forward and let you know, because it will be different, and I'm sure Mr. Trask will probably help explain that when we do have one before the board. And that's all I have. Thank you very much.
Board have any comments?
What else do we have on there? I'm sorry.
All right.
So I guess we adjourn.
Okay, we'll adjourn the meeting at 4:50.
Oh, took it every month now.